praying for another interim order.
If the lordship observes that, so that we need a protection only, protection from death. That's all.
Already
Nothing
it
else.
is there, Lordship. Earlier it was there.
If they assure that they will not vacate,
No, will not, without assessment, Lordship will not demolish any building, Lordship. Already 3G notification has been, the assessment has been done of the building.
let us file affidavit,
with
lordship, that they have done an
100%
assessment.
solution, Lordship.
Give a copies to us.
Yes, yesterday, Lordship, I have received the instruction. By Wednesday, Lordship, I will file the in the meantime.
Heard the council for the Learned Standing Council, NHIDCL, submits that she has received instructions and would like to bring it on record. So, by earlier order dated 22/04/2024,
Yes,
the court had permitted the Standing Council NHIDCL to file additional affidavit to bring on record the stand of the respondent regarding the assessment and compensation of the zirats. So, however, today when the matter is called up, MS, the Standing Council, submits that the instructions have been received, but the affidavit could not be filed. Instructions were received yesterday.
Yes, Lordship.
The affidavit could not be filed. She
Because the notification
submits
was
that the
issued on
affidavit will
12/5.
be filed. Will be filed by 29th of May. Stop.
Next.
By her, it is also seen that by order dated 4/4/2024, this court had observed that the petitioner is not entitled to continuance of its interim order because the national highway is undoubtedly an infrastructure project. So the interim order that was passed earlier is the order granted by the court on 15/9/2023, directing status quo as regards the RCC building and the land of the writ petitioner to be maintained till the next date. Stop. This interim order, this status quo order was subsequently extended. Stop. Learned Counsel for the respondent submits that by the order dated 4/4/2024, the status quo order was vacated. However, on careful perusal of the order dated 4/4/2024, there is no direction. There is no specific direction that the status quo order is to be vacated, or not continued. Stop. This court had merely observed that the petitioner would not be entitled to continuance of the interim order because NH is undoubtedly an infrastructure project. Under such circumstances, at this stage, this court is not inclined to accept that the status quo order has been vacated. Accordingly, matter be listed again.
Next week, Lord.
You said you are filing it on 29th. When are you filing it?
Yes, 29.
You are filing on 29th,
No, I'm filing on Monday, Lord.
Monday. So we are listing it on 29th.
29.
Matter be listed on 29th.
Public.
Mr. R.P. Kakoti, Senior Counsel, assisted by Mr. Mandal, appeals for the petition.
Public.
Public.
I do not know, I could be wrong, but this is my understanding that there is no specific order.
Lordship. Lordship
There is
understands
no
the correct-
specific order vacating.
There is no specific order to vacate.
Public.
Obliged.
Public.
May here we have challenged the impugned resolution. In fact, the
How is this
notification-
petition maintainable? You have been debarred by the Bar Association.
Yes.
Then you
Now-
go and file a suit, get an injunction,
Now, Lordship has seen, without any notice, any show cause.
whatever it may be.
Yes.
How can we issue a notice or orders against the Bar Association? Is it a registered body? Is it a registered body?
Now the Bar Association of
Dhubri, where is that? Gosaigaon.
Gosaigaon.
Is it a registered body?
I think it is under the Bar Council Act.
They may be under Bar Council Act. But Bar Council has not divided you.
My lord.
Bar Association.
Yes, Bar Council also is made party.
Maybe you can make anybody a party, but your grievance is against the Bar Association.
My lord.
Is it a registered body? Is it a legal entity?
I think, my lord, it has a legal entity.
Oh, must be registered.
Yes,
Is it?
I think, my lord, it is registered.
No. Your thinking will not do. Give us the details. You can't think. We can't pass orders on your thoughts. You
My
give
lord.
us the materials for us to pass orders.
Yes, I'll take instruction.
Mr. Mondal, Learned Counsel for the petitioner, submits that you'd like to obtain instructions in response to the pointed query by the court as to whether the Bar Association Gosaigaon, respondent number 4, is a registered body and therefore juristic person. Stop. Matter be listed after
After a week.
one.
Oblige.
Lordship, I beg for adjournment for today as the learned senior counsel is to his native because of his further ill health.
It is submitted on behalf of the counsel for petitioner that he is out of station. Learned Counsel MS
Roy.
A.
Roy.
Roy, raised for
Petition.
for how much time?
1 week, after 1 week it may be.
Praise submits that the matter be listed after 2 weeks. Mr. U.K. Goswami, Learned Counsel, appears for the railways.
All the respondents, not the railways, my lord.
All respondents. For all the respondents. As CGC. List after onwards.
Matter.
My lord, regarding item 4, my lord, I got affidavit on last week, Monday, my lord, so I need some time to rejoin that.
Item 4, Mr. S.C. Biswas submits that an affidavit is filed by the respondents have been served. You'd like to file a rejoinder
Yeah.
to the said affidavit. He prays for 2 weeks.
Little time, 3 weeks time, my lord.
3
My lord,
weeks.
we have.
You have an interim order.
My lord, if the project, it has been.
2 weeks
stopped,
time
my
will
lord.
be given to.
2 weeks time.
You have an interim order.
Yes,
Yes,
they have been given.
all are protected in interim, my lord.
All are protected, my lord.
So
Because
therefore-
they, my landlord had illegally want to encroach my land, my lord.
All right, we'll
I
examine.
am not commenting on merit. Why is commenting on merit?
Definitely, I'm saying, I am just saying that.
Let the matter
your
be
case is
listed
the-
after 4 weeks, after 2 weeks, sorry. Enabling the counsel for the petitioner to file the rejoinder affidavit. Mr. R. Borpuzari for finance, Mr. C. Burwa for
6.
what? What is 6?
It is NHA,
NA,
National
National
Highway
Highway
India.
Authority. Mr. N. Goswami for respondents 2 and 3. MSM Das for PWD. Okay.
My lord, I appear for revenue, my lord.
Revenue
Revenue
Department.
department. My lord,
Revenue
may I
Department.
pray for a fixed date, my lord, with all respect. My lord. Any date, my lord.
10th, my lord. May I pray 10th.
10th,
10th, my lord.
10th of
I'm so obliged. my lord.
My lord, interim shall continue.
interim order passed earlier will continue.
In items 5, 6, 7,
Hmm.
the same order may be passed.
5, 6, 7 be listed along with item number 4.
The interim order may pass same date. 10th.
Interim orders passed in all the matters will continue. All matters be listed on 10th.
In fact, my lord, we have received an interlocutory application today, my lord, in item number 6, where my learned colleague is appearing. My lord, they have filed an application, my lord, seeking amendment of the writ petition. If they come in the meantime, my lord, we will traverse, my lord.
They may file because of something that has been disclosed in the affidavit in opposition, that item number 6 required to be amended. That
So are
will
you
be-
pressing the IA or not?
Yes, because that IA has to be argued.
IA
It has
IA is
been-
not
they-
listed.
Not listed. It has
no,
been
it's
served
not
only
listed.
today.
Let it be listed.
My lord.
As and when it is.
Let that also come up on
You get it,
Look,
make a mention and
it is
pursue the
what
matter
my-
with the registry and get it listed.
Yes, we'll get.
I'm so obliged, madam.
Problem.
Yes.
In this case, file an application before the respondent number 2 regarding allegation against respondent number 3 also. The allegation that he has given more than one connection and subsidized connection and earning which is not permissible
He has given more than one connection to whom?
to other customer also.
Other customer.
And
How are
we
you
demand
affected? How are you affected? How are you
as a
affected?
public road.
You represent before the IOC? Who?
I made an application before
Bharat
the,
Petroleum.
yes, I made an application that has not been disposed of till today.
Then
No, we are inquiring the matter, madam.
you inquire and pass orders?
Yes, madam.
Where is your application?
Page 10 lordship.
Page 10.
Before, madam, kindly see, madam, what right has been violated, madam. For the petitioner, madam.
Whatever it may be, you
Yes,
see
ma'am.
you
Yes,
examine
ma'am.
and find
What
out
we are
if
examining,
the,
madam.
if the norms are not
Yes,
followed.
madam.
Then what steps
ma'am.
you should take, you examine and
I
see.
spoke to the madam, authority, madam, within 2 weeks, madam, we will dispose of, madam.
That will be petition will be disposed of. Lord.
Heard learned counsel for the parties. The petitioner is aggrieved by the uh, irregular activities, illegal or irregular activities carried on by the private respondent number
Okay, madam. We represent,
3, who is the agent for distribution of cooking gas of the respondent number 1, namely the Bharat Petroleum Corporation Limited. So, petitioner is a consumer of respondent number 3, and it is his
so he is
submission.
on a consumer, madam.
Consumer.
Not a consumer.
I'm a consumer also.
His son and wife was the consumer, my lord. And his allegation was that I, as an agency, I gave gas connection to 2 members in one family. But the petitioner here is not the consumer. My.
Oh.
His son and his
Petitioner's son
wife
and
was the
Not
daughter-in-law
consumer. I made a step in paragraph 2 Lord.
is a consumer. The grievance of the petitioner is that the
No, madam, paragraph 2.
respondent number 3 has distributed more than one connection beyond the norms permissible to other consumers. Stop. This is subsidized gas. This distribution is made in respect of subsidized cooking gas. Stop. Under the scheme and the norms, there is one connection required to be granted to one family. One connection per family.
Per family.
That is his version, madam.
No, as per your scheme,
Madam, to my instruction, madam, there is no such, madam, scheme, madam.
right? He submits that one connection per family. So he raised his objections before the authorities concerned by filing a representation dated 2006-2023, which was stated to be received in the office of the respondent number 1.
Respondent 2 Lord. 2 Lord.
Respondent number 2. Stop. Land counsel for the petitioner submits that although these grievances have been raised, they have not been redressed, and the respondent number 3 is carrying on the illegal activities by distributing gas cylinders without following the norms and procedures, causing great harassment to the local public. These submissions of the petitioners are stoutly denied by the counsel appearing for respondent 1, 2, and 3. 1 and 2 and 3. Both the counsels, learned counsel, submit that there is no such scheme or norms that each family has to be granted one gas connection. And it is also submitted that the petitioner is not a consumer, rather his his son is a consumer. Stop. Therefore, he cannot have any grievance. Stop. His son is not before this court. Stop. The limited prayer before the court the writ petitioner is that his representation has not been replaced. Counsel for the respondent number 1 submits that the department is actively considering the representation and will take steps to dispose of the same within a very short period of time. Taking into consideration the submissions made by the learned counsel for the parties, more particularly the statements, submissions of the learned counsel for the respondent number 1, the writ petition stands disposed of with the direction to the respondent number 1 to dispose of respondent number 2 to dispose of the representation dated 2006-2023 stated to have been filed by the writ petitioner pending before the authorities, and after due examination of all attending facts and circumstances, the representation be disposed of with a speaking order. So of any such order that is passed, a copy thereof shall be served on the writ petition. The entire exercise be carried out within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed.
I have also submitted my response to the representation.
The counsel for the private respondent number 3 submits that in response to the representation submitted before the court, he has also submitted his response before the respondent number 2. The respondent will take into consideration all the responses received from both the parties and thereafter pass the speaking order. Yeah. Yes. Of interim order, the penny stands march. Yes.
May it please the Lordship. Lordship, this writ petition is filed for the mutation of the land in the name of the writ petitioner. On the last day, the respondents were to seek instructions regarding the appeal file.
Why have you not approached the DC's office?
First of all, we have applied for an application that was rejected.
Where is the rejection order?
Rejection order has not been annexed.
Then?
But thereafter, they have approached for an appeal, but there is no information regarding whether the appeal is being registered or not.
You file an RTI? Find out.
The petitioner stated that they have done that, but till that no information is with
No,
them.
but you show from an RTI that it was done, or you have filed an RTI, they have not proceeded with the information. There are provisions under the proper statute before filing a writ. You have to explain that there are no alternative remedies, or alternative remedies available are not efficacious before we even issue a notice. You think about it. Matter be listed after 2 weeks, enabling the learned counsel
Late date may be fixed.
to apprise the court what steps have been taken under the provisions of the Assam Land Revenue Regulations in response to the claims of the writ petition prior to approaching the writ court. We're not fixing a date. Let it come after 2 weeks.
Much obliged.
Oh, this is relates to NRC, malab. My family members, malab, parents have got, my sister have got NRC, malab. And even his name along with the family members are reflected in the NRC also. Page 28, malab. Page 24. NRC also, malab, his names have been listed along with his parents. And the petitioner's son's name is Ayush Sebat. His mother has approached, malab. The petitioner's biometrics was taken on 11/6/2019. In spite of his name in the NRC, others family members have been issued with the other enrollment. Page 19 is the father, page 20 is the mother, page 21 is the sister. And he has this year appeared in HSLC, he pass out. Malo next day should be malo requiring this other for appearing in the NEET, JET, malo in all other competitive exams, malo. I have given the annexes. So, since this is not a case that his name is problematic, not reflected in the NRC, they cannot issue the Aadhaar, my lord. My lord, the
No,
petition,
you are filing a writ on whose behalf?
my lord, the son, my lord, Ayush Sabat,
The mother is filing.
mother has filed. Piyajashini is the mother, my lord.
Yes, yes.
Now, my lord, in this connection, even my lord, notice was served. The reply, my lord, page 29, third paragraph, my lord. Page 29, third paragraph. It is learned that the government of Assam has taken up the matter related to NRC biometrics hold cases for other with registers in India because RGI is the final authority for NRC related matters. Till a clarification received from RGI and the matter is communicated to UIDAI by the Home Political Department Government of Assam, Aadhaar number cannot be issued till then. But then, my lord, this is contrary to page 24 because I am placing that, my lord, because his name, if not appeared in the, my lord, NRC, then it would have been a case for holding. But his name is appeared in the NRC, my lord. Supplementary final list, inclusion of final NRC, my lord. Page 24, as I just shown, my lord.
Yes.
I have received instruction, Lordship. Because of NRC, his number cannot be issued. And the annexure 4, page number 24 is draft. Final list not served to the department, Lordship, by state home and political departments, state of Assam. And I have produced the instruction, Lordship. And similar matter is also pending before this honorable court, Lordship.
No, who is at serial number 3?
My lord, this is the, my lord, son of the petitioner for whom
The
they
writ
have-
petition is filed.
Yes. My lord, and the first, my lord, first line of page 24, my lord, it is say the final NRC. Supplementary list of inclusion and exclusion of final NRC under 7 of the schedule to citizen rules 2003. Father Otulananda, his my lord, Aadhaar is at page 19. Creation is the mother, my lord, our NRC page 20. And my sister, my lord, Adesa Sabat, page 21. Even sister has also been issued with, my lord. And the problem he
Page
would face.
24 is not final list, supplementary list of.
Within bracket final NRC.
Another repetition is pending before this honorable court, and that petition affidavit has filed already. I need some time to file affidavit in this matter also, Lordship.
It's fine.
And this matter also tagged with the another petition, maybe if possible.
So let it remain here. What is the, why
Yes,
should it be tagged?
Yes,
You file your affidavit
Yeah.
if you want to file. When can you file it?
2 weeks required, Lordship.
Okay, I heard Mr.
BK
B.
Alram BK Das.
Bikedas, yes. Counsel for the petitioner, MSS Burwa for the. You are appearing on behalf of
Central CGC, respondent.
CGC. You are appearing for 1, 2, 3, 4.
1, 2, 3, 4.
3, 4. Mr. S. Sharma for
As for what?
Burwa for 5 and 6.
Can you five and
No, 3, no.
5 and
5 and 6. So, learned government advocate submits that she has received her instructions and would like to bring an affidavit on report. Learned CGC. She prays for 2 weeks' time. Let the affidavit be filed. Matter be listed thereafter.
Lordship, let's fix a date, my lord, because some urgency is there, my lord.
2 weeks. Matter will be listed on 12th of
Right.
June.
Okay.
12th.
Please, Lordship.
Yes.
Lordship, the petitioner preferred this petition for impugned demand cum show cause notice, Lordship, which has been issued on 24/8/2019, Lordship.
Oh, it's good to see you on this side sometime. Yes.
Lordship, thereafter, Lordship, a petition was filed, admittedly, Lordship, before this honorable court, where honorable court has issued notice of motion, Lordship. But subsequently, Lordship, the petitioner counsel who was conducting the case, Lordship, during the COVID period, they lost contact and subsequently, Lordship, for non-prosecution, the matter was dismissed, Lordship. But Lordship, presently the petitioner again has been issued with a notice, Lordship, for appearing for personal hearing, Lordship. And in the meantime, Lordship, the petitioner also have gathered, Lordship, some documents from the Indian Oil Corporation, because he is basically a contractor doing contracts with the Indian Oil Corporation, and his nature of job is the manpower supply, Lordship. Lordship, when during the introduction of the service tax, Lordship, certain items were put in the negative list, Lordship, and accordingly, Lordship, one internal notification of the Indian Oil Corporation was also circulated among the contractors, Lordship, where they have introduced reverse charge method, Lordship, and wherein for few types of contracts, Lordship, some portion have to be paid by the service receiver and some to be by the service provider. In this particular case, Lordship, first it was introduced 25% is to be paid by the service provider and the remaining 75% to be by the service receiver. And subsequently in 2015, Lordship, it became 100% by the service receiver, Lordship. Anyway, Lordship, the petitioner also filed his ST3 returns, Lordship, because the service tax was always a self-assessment, Lordship. And accordingly, Lordship, he filed all his ST3 returns, and whatever is tax admissible to him, Lordship, he paid this. But Lordship, in 2019, the petitioner was issued with the show cause notice, Lordship, where it has been stated that he was asked to provide some documents, but they, subsequently, Lordship, they have collected my income tax return for the period from 2013-14 to 2017-18, Lordship. And from my gross income, Lordship, they have now calculated a tax, Lordship, where I have been asked that I have fraudulently evaded tax. I have not paid the tax, and they have imposed a certain amount, Lordship, which I need to be paid. So my prayer before them is that because of the reverse charge methods introduced by the Indian Oil Corporation, because all my contracts with the Indian Oil Corporation Limited, Lordship, so I have been paying my tax as per the notification. This notification is at page 35, Lordship, which was introduced in 27/6/2012 and effective from 1st July 2012, Lordship. Lordship, in page 36, column 8, Lordship, here is manpower supply. Lordship may kindly note that first column is percentage of service tax payable by the service provider. It is 25%, and by the service receiver, it is 75%, Lordship. So accordingly, he paid all his tax, Lordship. The Annexer 8, this is a collectively I have annexed here, Lordship. So here I have paid all my tax, whatever is admissible as per my calculation, Lordship. And thereafter, Lordship, very recently, I have been provided with the page 91, Lordship. If the Lordship may kindly peruse page 91. The Indian Oil Corporation has provided me the documents, Lordship, where they have paid the portion that were supposed to be paid by him to the government exchequer, Lordship. Lordship may kindly note that the details of service tax deposited under RCM by the IOCL Digboy depend for the period from so and so, Lordship. And this pertains to the work order that was executed by the petitioner, Lordship. So from this, Lordship, it is admittedly that the tax has already been paid, lordship, and the petitioner, because of no reason, lordship, the provision that has been extended by the department, lordship, central excise departments, they have stated that this 73 section, this 73, they have invoked lordship for non-payment or short payment of list, and the reason is that from their view that I have fraudulently evaded tax, lordship. This is there. If your lordship may kindly peruse page 18, lordship, the demand cum show cause notice that has been issued.
Page,
Page 18, lordship, 1(8). This is the annexure 1, lordship. If your lordship may kindly visit the computation of service tax liability in the bottom, lordship.
Hmm.
Lordship, as the noticee did not submit any documents, there in reason to believe that the income amount on which the noticee
you are
paid.
called upon to submit in terms of 93.
Lordship,
You are required to submit details under in response to page 93.
yes, lordship, the page 93, I have been,
You did not submit.
lordship, I have received it now only, lordship. This was,
It was issued in 5/9/2016.
no, lordship, thereafter I have given everything.
Hmm.
This was, but this is not up to their satisfaction, lordship. And the documents that they are denying, lordship, everything was with them, lordship, because they have also audited the tax that I filed, lordship. And this is mandatory as per as per the rule also, lordship. So I have, and during that period, lordship, and moreover, lordship, the period, actually the period, if your lordship may I provide a copy of the service tax? The section 70, which they have invoked, lordship. I have a downloaded copy, lordship.
Yes.
In page 16, lordship.
Yes.
Section 73. Recovery of service tax not levied or paid or short levied or short paid or erroneously refunded. 1. Where any service tax have not been levied or paid or has been short levied or short paid or erroneously refunded, Central Excise Officer may, within 30 months from the relevant date, serve notice to the person chargeable with the service tax which has not been levied or paid or which has been short levied or short paid, or the person to whom such tax refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice, provided that where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded by reason of fraud or collusion or willful misstatement or suppression of facts or contravention of any of the provisions of this chapter or of the rules made thereunder with intent to evade payment of service tax by the person chargeable with the service tax or his agent, the provision of this subsection shall have effect as if for the words 30 months, the word 5 years had been substituted. And in the show cause notice itself, lordship, in the page 19, they have invoked the extended period of limitation, lordship. And the extended period of limitation is also, if provided this some certain condition is there, lordship, where it is fraud, collusion, willful misstatement, suppression of fact, or anything contravention of any of the provisions of the of this chapter, lordship. So admittedly, lordship, when I have paid, this is whatever has been assessed, lordship, accordingly I have paid. And there are also the RCM introduced by the service provider, the service receiver, lordship. So they have circulated that I have to pay my tax according to the notification that they have implemented, lordship. So my humble submission before your lordship, and one more thing, lordship, the period, lordship, the 30 months. 30 months also have elapsed. And this one I have explained in my petition, lordship, in paragraph in paragraph 14, page 9, lordship.
Yes,
Bec-
okay.
Yes,
Let us
Lordship.
hear the respondents.
Lordship.
Approximate which took us to see the improved notice was issued in 2019. That was proved under challenge with this honorable court by writ petition number 7506. May come to page 24. The writ petition was dismissed for default. Thereafter, Lordship, page 26 is the operative part.
What was challenged here?
Same notification, same notice.
Same notice.
Same notice was put under challenge.
Lordship, now I have received with this one, Lordship, page 93. This page 93, this is there, Lordship, because I have been asked for personal hearing, Lordship.
Lordship, what happened
Page
thereafter?
93 also is approved.
No, Lordship, 93 is the other one which I have challenged because I have excess payment, Lordship. I have,
What have you challenged in the earlier writ petition?
Lordship, the notification. Now, Lordship, this,
Which notification?
Same notice. Same
that's
demand.
demand come show cause notice, but now I have challenged this 15/4/24 order also. So 15/4/24, this one also, Lordship, notice.
15/4, where is that?
Yes, page 34, Lordship, Annexure 6.
34.
Yes, Lordship.
The personal hearing.
Yes, Lordship. And on the day of hearing, Lordship, I was there.
What happened after the show cause?
Yes, Lordship.
What
They
happened
have,
after the
they
hearing?
have, they have asked me to appear on 27, Lordship.
Hmm.
On 27 too, I was there, but no official was there. So page 28, Lordship, Annexure 5, I have put one written submission. Now again, they have asked me on 15/5 that for personal hearing.
No, so what is your challenge here in the writ petition?
Lordship, my challenge is that this is basically time barred and
See,
Lordship.
you are challenging the demand come show cause notice of 24/8/2019.
19, Lordship. Yes, right. I also have stated, Lordship, that I came before your Lordship.
That's
There was
right.
notice
So
was
if it
issued.
is dismissed for default,
Yes.
you file a restoration.
Yes, Lordship. No, Lordship, the new thing has come. And one more thing, Lordship, that I have provided with the RCM, that means the portion of payment that has been paid by the IUCL, Lordship. So they have to take
Pertaining to which period?
the whole period that I have been demanded, Lordship.
That's right. So that was under
2013-14 to 2018, Lordship, 17-18, Lordship.
See, it was challenged.
Lordship.
It is dismissed. Why have you not filed a restoration?
Lordship, this was, they have no contact with the earlier council, Lordship.
Maybe
who have
you have a
actually
contact now. Now you're before the court.
I am before the court, Lordship, but
And your prayer in the writ petition is still the 2019 demand notice only.
yes, Lordship, but subsequently that I have been issued with the notices, this
Maybe,
also,
but
Lordship.
there's no prayer for interference or challenging. Nothing.
Yes, Lordship, I have made it that,
Where is it?
this one, this, 15/4/24, Lordship.
No, 15/16, you read your prayer. Your prayer is for setting aside and quashing the demand notice.
Yes, Lordship, on the ground of this, the portion, because at that time I was not provided with these things, Lordship.
Which was the subject matter of the earlier writ petition.
Lordship,
Seemed to be dismissed.
yes, Lordship, admittedly, I also have submitted, Lordship.
Now
this
the
thing.
question is, why have you not restored it?
Lordship,
What is your
restoration
difficulty in restoring it, or at least filing an application for restoration?
Lordship, then
Restoring.
I have to take instruction from my client,
Of
Lordship.
course you have to. You have to advise your client properly.
Yes, Lordship.
There is
Lordship,
no
fix
liberty
it on
grant.
Monday, Lordship, Monday, on Wednesday, Lordship. This
The
particular.
request of learned counsel for the petitioner, matter is deferred to be listed on 26. Mr. KL appears for respondent number for the private respondent. Sorry, for GST.
On 29th, Lordship.
29th,
Lordship. Next Wednesday, Lordship.
next Wednesday. 29th. No?
Yes, Lordship.
29th.
Lordship, here facts are almost same, but here I have been served with show cause notice on 13/12/2020, Lordship, during the COVID period, Lordship. Thereafter, Lordship, there was all where there was lockdown, there was limited functioning of the offices. Lordship, the petitioner could not collect anything in his favor, Lordship. And that apart, Lordship, they have asked for the period, Lordship. This is of 2014 15 to 2017-18. This is from October 2014 to June 2017, Lordship. But as per the section 73, Lordship, this 30 months have already elapsed, and that I have stated, Lordship.
You have to, where is the order of assessment? There must be there's no order.
No, Lordship, proceeding is going on. Suppose notice has been issued. They submitted their reply.
No, but you,
Then Lordship, page 33,
mm,
16th May was fixed for personal hearing.
personal hearing.
It didn't appear. Now this is-
Lordship, kindly peruse the page 8, Lordship.
Page
From
eight.
Yes, Lordship. From October 2014, Lordship. This time 30 months has already elapsed on June 2017, Lordship. Then subsequently, Lordship, this April to June, these also have elapsed on December 2019, Lordship.
See,
And they have,
madam,
Lordship.
these are financial acts. There is a detailed proper code. These acts are a code in itself. There are officers identified, procedures mentioned, responsibilities are fixed. So they have undertaken this process. Now, unless you want to challenge on the ground that they are not the authorized person, or the sections under which it has been issued, they are not empowered to do so, merely because you have submitted the tax or you have paid the tax and the authorities examining the matter, it can't be a ground for the writ court to interfere. Where is the assessment order passed? Where is the demand notice? You are
Demand notice, Lordship.
no, you are challenging
This
the
is the
demand.
demand come show cause notice.
That's right. So this demand
Page
notice is
15.
there.
Yes, Lordship.
Pursuant to the demand notice, you have been asked to show cause, you have shown cause. Now, unless you make out a very specific case that this demand notice could not have been issued because the entire amount is time barred or
Yes, it is time barred. That I have said, Lordship. It is time barred. And that apart, Lordship, section 73, Lordship. This is because they have invoked this 5 years time limitation, Lordship. This 5 years cannot be invoked, Lordship, because there is no fraud and nothing, Lordship.
whether there is fraud or not, this is what they're examining. They'll have to pass some order.
Definitely, they have to pass
What is
order,
the
Lordship.
order?
But apparently, Lordship, the shockers that they have issued, Lordship, this is time barred as per the act. They are relying on, Lordship. And these 5 years can be invoked only on special circumstances, Lordship. Lordship may kindly peruse the page section 73(1).
Yes.
Where any service tax has not been levied or paid, or has been short levied or short paid or erroneously refunded, Central Excise Officer may, within 30 months from the relevant date, serve notice on the person chargeable with the service tax which has not been levied or paid, or which has been short levied or short paid, or the person to whom such tax refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice, provided that where any service tax has not been levied or paid, or has been short levied or short paid, or erroneously refunded by reason of fraud, collusion, willful misstatement, suppression of facts, contravention of any provisions of the chapter of the rules made thereunder, with intent to evade payment of service tax by the person chargeable with the service tax or his agent, the provision of this subsection shall have effect as if for the words 30 months, the word 5 years had been substituted.
What is the relevant date?
Relevant date, Lordship, in page 8 that I have stated, Lordship. I have made it bold, Lordship, because from October 2014, they are charging, Lordship. For October to December 2014 Lordship, the relevant date is January 2015 Lordship, and the 30 months elapsed on June 2017 Lordship. Then subsequently all these Lordship, and if I can take the Lordship, because they have demanded me up to June 2017 Lordship. So June 2017 has already elapsed in December 2019 Lordship. And they have served me the show cause on 31/12/2020 Lordship. And within this time, Lordship, they have not issued me any show cause, because the term from 2014 Lordship, I have paid all the tax that were I was liable to pay Lordship, and as per the RCM, I have paid the tax, and I also have annexed the portion of the payment made by the IOCL Lordship, because I am also a contractor with the Indian Oil Corporation Limited, and accordingly, they also have paid their portion of amount, Lordship. So they are putting liability only on me, Lordship, knowing the fact that this internal circular was issued as per the order of the authority concerned, Lordship. Because
Mr. KL, you get your instructions as to what is the ground for evasion.
Yeah, I've obtained instruction, Lordship. Please to see page 16.
60.
Yes, page 16 of the rate petition.
Yes.
Invocation of extended period of limitation under proviso to subsection 1 of section 73 of NHIDCL. Whereas the said notice being registered under service tax, they were fully aware the fact that the service provided by them were taxable in nature, and they were in obligation to discharge their service tax liability.
Correct, we have seen it. Therefore, we are asking you.
No, Lordship, please to see further. Next paragraph, last paragraph. The due date for filing ST3 for the period from 14 to 2015 was 25 for 2015. As per the para 6 of the official gazette of India, dated 31/3/2020, the due date for issuing any notice which falls under the period from 2/03/2020 to 29/6/2020 stands extended to 30/6/2020. The relevant para is reproduced as under. Notwithstanding anything contained in Central Excise Act, Custom Act, except section so and so, the custom so and so, with effect from first day of July.
When did you file your returns for that period, relevant period?
For the when this was due, Lordship, I have not annexed the ST3 return.
No, but have you mentioned the dates?
The dates I have not, but I have stated that I have filed the due return on time, Lordship.
You produce the dates.
Lordship, I can produce.
Which period when you filed?
Yes,
Extended, Lordship,
I
during
can.
the COVID period.
Maybe, but it was extended, okay, but this is, you are invoking this clause for the point, only for the only ground of suppression.
No, Lordship, explanation is there.
Willful, not willful disclosure.
There, Lordship, may I allow to read. Falls during the period from the 28th of May 2020 to 29th day of June 2020, and as such, after 29th day of June 2020, the central government may by notification specify the completion of such action. A. Completion of any proceeding for issuance of any order, notice, intimation, notification, or sanction, or approval, whatever name called by authority, commission, tribunal by whatever manner name called for. B. Filing on appeal, reply, application, or furnishing any report, documents, written or statement by whatever means called, shall, notwithstanding the completion or compliance of such action has not been made within such time, stand extended to 30th of June 2020, and as such other date after 30th of June 2020 as the central government by notification is specified on this behalf. As per official gazette of India dated 27/6/2020, the relevant para is reproduced here. On the 29th September 2020 shall be and the date of the period during which that time limit is specified in or prescribed or notified under Central Excise Act so and so or the Finance Act 1994 falls for the completion or compliance of such action as specified under clause A or B of the said section. 2. The 30th day of September 20 shall be and date for which the time limit for completion of such action shall stand extended. Again, the official gazette stands or lordship may then may come to next paragraph, subparagraph 2. The 31st day of December shall be the date on which the time limit for compliance shall be stand extended. Not as provided under section 73. It was extended by special notification, lordship. And thereafter, lordship may come to page.
This is extension of 30 months.
Yes. And lordship thereafter, they appear before the authority, file their reply. Now, lordship, notice for personal hearing was given. Nothing has been finalized. Everything will be considered. And lordship may please to see what document they have submitted. Page 23, the list of documents enclosed.
Prime facie, it appears to be within the extended period.
No,
Yes,
lordship, box extended period, lordship, kindly peruse then page 18, lordship, what they have stated. Page 18, in the middle, lordship, after the these columns A, B, C, D, E, F, below that, lordship, all the above facts establish that the said noticee has willfully suppressed material facts providing taxable service as stated above to his service receiver with an intent to evade payment of service tax amounting to rupees so and so only, and they rendered themselves liable to penal action. Lordship, how they can say, lordship, that I have willfully suppressed when I have paid my tax, lordship?
Which is why they have issued.
Yes, lordship, then how the 5 years they can, because they
Not
have
5 years, not 5 years. This is 30
30
months.
months, lordship, 30 months.
30
30 months have already elapsed
No, no,
in
it is
2019.
no, it is extended.
It is that extension, lordship, only is subject to that.
Subject.
Fraud, willful
no.
suppression, misstatement, lordship, these things,
This is
lordship.
because of the COVID. It was extended.
Lordship, in 2019, there was no COVID. 2019, there was no COVID, lordship.
No,
COVID
subsequently it was
subsequently,
extended.
lordship. How they can invoke which already have expired, lordship?
All right.
Which
you get your
already have
instructions.
expired.
We'll see. You tell us the period when it got
Yes, lordship.
expired.
I shall.
That is what is
I shall,
official. That
lordship.
is what we are
Yes.
asking you.
Yes, when I have lordship, I shall.
What is the relevant date and what is the period to
Yes,
expire?
relevant date I have mentioned, lordship, in the
What is the period for expiry?
Yes, lordship.
That is not there.
When I paid lordship, I shall definitely produce lordship.
You produce it.
Yes, lordship.
We'll fix it on, when was it fixed? The other matter?
29.
29th, lordship.
29. So let
Lordship.
these matters be listed. All the other matters are similar.
Yes, lordship.
List
These are all, this matter and the next matter is same, lordship.
29th.
Lordship.
In order to submit that, this is beyond limitation, you give us the dates when you
Yes, yes.
submitted the
If-
return. And
yes,
what is the
lordship.
limitation date?
Lordship. I shall. Deeply obliged, lordship. Lordship, fixing the other one also on 29.
Yes, all
Lord.
three matters on 29. Third learned
Lord.
counsel for parties. Counsel for the petitioner will furnish the dates of filing the returns for each year in question before the court by the next date fixed,
Lord.
fixed on 29th.
Lordship.
Mr. Kyal is at liberty to obtain instructions and place it before the court, if so advised.
Deeply obliged, lord.
May I please your lordship? Lordship, this case is basically a third case from the area Naharkodia, my lords. Now, this purportedly appears to be a case of eviction. However, in the previous cases, my lords, there had been specific direction passed by this coordinate bench of this honorable court. But in this case, we have been in possession of agricultural land, where we are indigenous cultivators in possession of the agricultural land. And in time and again, we have made representation before the appropriate authorities for settlement of land in our favor. However, no action has been taken in that purpose. However, in the adjoining areas, land has been settled by the appropriate authority. However, this time, my lords, what has happened that with all due respect, what it seems it apparent that the circle officer has tried to bypass all the provisions and the directions that have been given in the previous cases. This time, private contractors have trespassed into land which were in a possession, my lords, and for which we have approached the circle officer to understand for whom the land has been allotted to, or what is the status of the land, or whether any rehabilitation has been given to us or not. However, no requisite information is given. We are rather misbehaved, and even we have filed a case before the police station Naharkoti. However, no requisite relief has been given to us, my lords. That's our case.
What orders were passed in the earlier writ petition?
Well, in Kusumi Sonwal versus the state of Assam, basically what happened, they were using for the homestead purpose, my lords. Wherein, my lords, there were two specific directions that were given. The first direction was that person possessing Pradhan Mantri Awas Yojana houses were being to given a 3 lakh rupees assistance and a settlement of land. And rest other people were given the
Why
settlement of
did you
land.
file an RTI to find out your information that you want?
No, basically what has happened that we have approached the circle officer to basically tell us the status of the land, but however it is told that he has told that no, you cannot have the position of the land. Basically it will be taken of the this
File-
thing. And
file
anyways, my lords, in any
File
way,
RTI.
no, anyways, my lord, what has happened that we have applied to the Basundhara. We applied for the Basundhara and our application for Basundhara has been rejected. And for that purpose alone also we can, with my humble submission that we have proposed this, approach this honorable court, my lord.
Where is your application rejection order?
Rejection order is at, my lord, page number, my lords, 58. No notice has been given. And my lord, with regards to notice, this is in consideration before the division bench, my lord. Whether a rule under, whether a notice has to be given under 18.2 or not.
This is the government land.
Yes, my lord. They have applied for settlement of the land, my lord. And in Monica Bora, that is in the second case, my lord, what has happened that in a similar security case, the coordinate bench has directed the authorities to give us land if we are indigenous landholders as per land policy 2019, my lord. So the direction is given to comply with with the land policy 2019, my lord, for settlement of land.
You get the instructions why it was rejected, whether their claims were examined prior to rejection.
Yes. Lordship, my lord, this is not basically a writ petition. It is an RTI application in disguise. Lordship has put the right question. If my lord may be pleased to come to page 14 of the writ petition. Kindly see what they are seeking. It's a gross abuse of the process of law. Page number 14. Earlier, 2 rounds of litigations have, my lord, taken place. Both the writ petitions stood dismissed. The only, my lord, handle they were given that you apply for settlement or allotment of the land and the authorities will consider. Now, my lord, admittedly, the land over which they are, my lord, residing, that is reserved, my lord, for Naharkoti Stadium, is the public purpose. Kindly see, my lord, page 14.
No. First thing is whether
Yes.
their claim that they were in possession of that particular land or cultivating or whatever they're doing has some basis or not. Assuming or whether according to the government it was a completely vacant land, uninhabited by the petitioner or any other person. Therefore, at the relevant point in time, it was handed over for public purpose. If it was under their possession, should know, is there no provision under the law for the authorities to make an inquiry and find out?
Yes, inquiry
And
has
as
been
per
done.
the
Yes.
land policy, you are required to give them alternative land.
Now the difficulty is that, my lord, they are seeking allotment or settlement for that matter over those part and parcel of land, which is not permissible. Land policy does not say. I cannot compel
That's
the
right.
authority,
So
my lord.
we want to know on what prior to the order being passed by the circle officer, what is the basis of rejection? That's all we want to know
It is there,
for
my
the
lord.
time being.
No, lordship will kindly see page 58, which my lord's attention has been drawn. Kindly see, my lord, page 58.
No, that's right, but there is no finding whether the petitioners claim that they were settled over, they were in possession of that land is correct or wrong, incorrect.
No, they had been paying Bedokoli Zarimana. They were in illegal occupation of that plot of land. Kindly see, my lord, that Bedokoli Zarimana. I don't know why my friend is not, my lord, referring to those pages. Kindly, lordship, may please to come to page number 31. Kindly see. Law is clear, my lord. Radhagana Supreme Court has deprecated that practice time and again. No Bedokoli Zarimana. Kindly see, my lord. They are in wrongful occupation. They are encroachers. Page number 33. 31. Kindly see, it is Bedokoli Jarimana. What more is required, my lord? Then, my lord, page number 33, Bedokoli Jarimana. They are illegal encroachers.
They are not claiming that, you see, a person is in possession of a land. If it is vacant, obviously the land belongs to the government.
Yeah.
If it had belonged to, if it was a patta land of somebody else, then that person or owner or owners would have complained before the authorities concerned. So, under the regulation, you have extracted a fine for occupation of that particular land. For what purpose?
Yes. Now the authorities could not have extracted that fine. It is that practice is seriously deprecated in Radhakano 1996 8 SCC, my lord. Supreme Court is clear. So therefore, what I am trying to draw, my lord, is that they are admittedly in wrongful occupation. So if I am in wrongful occupation,
No, so
that-
wrongful occupation and occupation of a government land,
yes,
government land, vacant government land,
yes,
or land which is not earmarked for any purpose
yes.
at the time when they're occupying, will not prima facie make it a wrongful occupation. They're unauthorized occupation.
Yes, unauthorized means
They're
wrongful.
unauthorized.
Yes, regulation 60.
Wrongful would be where it is earmarked
Yes,
for a particular purpose.
yes,
Signboards or indications are there to show that this particular land is assigned for this purpose, yet
yes, yes.
they were in occupation.
Because my
Now,
lord,
what is the case here?
case here is that, my lord, they were in occupation, wrongful occupation of the government plot of land.
No,
So
that-
therefore,
Is
my
it
lord,
was it a vacant plot? Was it
yes,
was it a
yes,
plot
vacant
of
plot.
land which was never
Yes,
at
yes,
that point in time, which was
Yes.
never assigned to anybody?
yes. Everything has been pre-decided by this honorable court. Kindly see, my lord, there are two judgments.
Yes.
And therefore, their prayer at page 14. They are not
So
even
where are the orders of the court?
Yes, one lordship will find, my lord, it starts. My lord, the first decision, lordship, it starts from, my lord, page 75. Page 75.
Yes.
Page 75, operative portion, lordship will find at page 85. Page 85. In that writ petition, my lord, there were altogether 15 numbers of writ petitioners. Now, kindly see what are the findings of the court. Page 85, my lord, the last paragraph. May I read it, my lord?
Hmm.
Therefore, this writ petition is being disposed of with the following observations and directions. All the writ petitioners shall be allotted land in the adjoining area by issuing separate allotment orders if not already done.
The present petitioner was a writ petitioner here.
No. They were not a writ petitioner. And kindly see, my lord, in case of 4 writ petitioners who had constructed dwelling houses with financial assistance under PMAGY scheme, they will be paid an amount of 3 lakhs. So we had volunteered, it was a concession by the government where learned Advocate General had appeared. It's as compensation for the houses so constructed. Upon completion of the process under serial number 1 and 2 above, the petitioners shall be given 15 days notice in writing, asking them to vacate the land of their own. If the petitioners or any of them fail to vacate the land, even after expiry of 15 days notice period, as provided by this code, in that event, the district administration will be at liberty to proceed for eviction of the petitioners from the land by demolishing the constructions therein without serving any further notice. So the court came to a definite finding that except these four petitioners, in fact, all the writ petitioners were in illegal occupation, but these four numbers of writ petitioners at serial number Roman 2, they had constructed houses by availing scheme under the PMKGY. So since they had availed the scheme, so that means, my lord, the government had, my lord, in a word, my lord, government had, my lord, waived their rights, my lord. Government had given a tacit acceptance to their occupation. So therefore, my lord, court directed that you pay rupees 3 lakh. Then, my lord, the second decision. Kindly see, my lord, the second decision, it starts from page 191. On the same part and parcel of land, page 191.
Yes.
Lordship may kindly, maybe please to, my lord, come to page 206. I will be reading, my lord, from paragraph 22 onward. These were the findings of this learned court. The court has, paragraph 22, the court has taken notice of the fact that applications were submitted by other petitioners other than the petitioner number 6, claiming themselves to be the deserving indigenous landless persons. In view of such claims of the petitioners and contrary claims from the end of the state respondents, this court is not in a position to determine such factual disputes, and such matter can only be gone into by a fact-finding authority. Notwithstanding the rejection of the applications of allotment settlement submitted by the petitioners earlier on the ground that the lands in respect of which these petitioners had sought allotment settlement had already been allotted or of the settled for government infrastructure and public playground, the court is of the considered view that they should be given another opportunity to submit applications seeking allotment settlement before appropriate authority on the premise that they are deserving indigenous landed persons and they are eligible to be settled under the Extent of Land Policy 2019. It is therefore observed, having regard to the fact situation obtaining in the case and taking into account the other obtaining fact situation, that in the event of these petitioners prefer any application for allotment or settlement of land under provisions of the Land Policy of 2019 before the competent authority as per the procedure, on the basis that they are deserving indigenous landless persons, the competent authority shall undertake a fact-finding exercise to find out the eligibility or otherwise of the applicant and thereafter consider the application on its own merits as per the provisions of Land Policy 2019. Having regard to the humanitarian aspect involved, this court is also of the considered view that such exercise shall be undertaken and completed within a period of 2 months from the date of submission of such applications. While parting with the writ petition and also by taking into the humanitarian aspect concerned, it is ordered that the state responsible shall provide reasonable opportunity to petitioners to vacate the land which are under their unauthorized occupation. Lord, will kindly mark it. The petitioners shall vacate the lands under their unauthorized occupation within a reasonable period of time, but not later than 21/2024. In the event any of the petitioners do not abide by this direction, the state respondents will be at liberty to take necessary steps for their eviction as per law. Now, where, my lord, they are seeking settlement of land where it is already been reserved. So therefore, lordship may finally come to my lord.
No, we are only asking you a very simple question.
Yes,
That from the order of rejection,
yes.
it is not clear as to whether the land was reserved or has it been reserved. And what examination on the field has been done by the circle officer before passing the order. That's all.
Yes, my lord, for my satisfaction, if my lord may be pleased to come to page 58. 1 second, my lord. Page 58.
If you are making it transparent, make it transparent.
It is transparent. Otherwise, my lord, if lordship directs, my lord, we are ready to produce the records. No difficulty at all, my
No,
lord.
we don't want to see your records. We are asking you on the reasons given by the on in the order at page 58.
Yes,
Land applied is already allotted.
allotted to government
So
organization.
you tell us on which date they filed application, which date the allotment was there. Give us the detail. That's all we are asking. Nothing more. How many is there any finding by the CEO that this land was already earmarked for? There must be some notings in the file. pursuant to which this order is passed. That is what all we are asking. Because this order does not reflect anything more.
It is an online application.
right.
So therefore, my lord, naturally it will be, my lord, in a sum and substance manner, my lord.
Ah,
So therefore, my lord, I am drawing my lord's attention to page 14. Kindly, my lord, see what is their prayer exactly.
no, we'll go into all this. You just give us the reasons, that's all, in support of this. You check up the file and tell us what are the reasons, that's all.
Lordship, then maybe please to issue formal notice of motion, my lord. We will file an affidavit.
All
Let
right,
the
all
circle officer
right.
file an affidavit.
Learned counsel for the parties issue notice returnable 4 weeks. The petitioners will, Mr. R. Borpujari, learned counsel appearing
My lord, I appear for respondent 1, my lord.
respondent 1. MSS Purva appears for 2 and 3. The standing counsel and government advocate appears for the respondent. This is the waive, however, extra copies be furnished within a period of 1 week from today. Let the respondents complete their instructions and file necessary affidavit if so advised.
Lordship is issuing a notice of for 4 weeks, my lord.
4 weeks.
My lord.
Right.
Much obliged.
Deeply honored.
May please, Your Honor. Matter relating to freezing of bank account, Your Honor. The notice by which my bank account has been freezed is number 40, my lord.
Who has directed freezing of the accounts?
The bank account was directed to be freezed by the investigating officer, Crime Branch Police Station, my lord.
Yes, madam, please get instructions. Why the account was freezed? Hard learned counsel for the parties. The grievance of the petitioner is that the bank account, savings bank,
Current bank account, my lord.
current bank account, maintained at AU Small Finance Bank, page 7, Mohali, in the state of Punjab,
Punjab, my lord.
bearing account number so and so, has been freezed on the instructions received from the investigating officer of
Crime Branch Police Station.
Crime Branch
Pandazar.
Police Station, Pandazar. Stop. Petitioner submits that this, as per the information available, this account has been freezed on the basis of the information received in response to an FIR lodged before the state investigating officer. Stop. Petitioner is a proprietor of MS Associates and he deals in rice, edible food items and animal fodder.
The petitioner is not the proprietor of MS Associate, man. He is the proprietor of Rudra Infrastructure. The informant
Huh?
of the FIR is the
Okay. Petitioner is the is a businessman undertaking coal trading.
Okay.
And he is a company / firm under the name and style of Rudra Infrastructure, having his office at Mohali, in the state of Punjab. Stop. Petitioner counsel submits that in response to the FIR lodged and currently investigated by the investigating officer, petitioner is not at all involved. Therefore, the freezing of his current account has caused severe losses and to him in carrying on his business as well as hardship. Therefore, he has approached his court. Let the government advocate obtain instructions from the investigating officer as to the reason why the account of the petitioner has been stated to be freezed. Extra copies be served within 3 working days to enable the government advocate to obtain the required instructions. Matter be listed on 7th of June.
Hello.
Yes, Mr. Sokian.
My lord, the simple the petitioner, my lord, file a complaint before the GMC at page 35.
Yes.
The respondent number, my lord, 3, has unauthorizedly, my lord, constructed an assembly house on a portion of the land of the petitioner. And this application was filed, and then my lord, the respondent authority, GMC, after inquiry, has issued a so-called notice of page 37 to the private respondent number 3. You are hereby asked to produce approval plan for the construction of your Assam type house, boundary wall undertaken at Madhurya, Lakhi Mandir Port to be undersigned within 9 days from the date of receipt of this notice. Then, my lord, the respondent, when they were sitting tight, that page 48, my lord, the petitioner has filed an application under the ITR. Page 48, Lord.
No, after the notice, what happened?
They are sitting tight. The law officer made a query, and law officer has admitted, I have annexed it, that he unlawfully has constructed the Assam Type House. It should have been demolished under the under section 337 of the GMC Act. The GMC is bound to, my lord, to remove the unauthorized construction.
Yes. So what happened in the RTA?
I tell you, they have replied at page, my lord, page 48. With reference to the subject cited above, I am to furnish here with information received from the associate planner, GMC, for information. In case you are not satisfied with due information, you may prepare an appeal before First Appellate Court Authority, GMC. Then next lordship page, page 49. With reference to the subject cited above, please find here with information under the RTA. Choose them for forward, onward necessary action. Then the lordship at page 50, 51, next page, lordship kindly see below portion. Perusing notes and the materials on record. On perusal, it appears that the order dated 28/9/15 passed by the court of Assam Board of Revenue Guwahati to maintain status quo is binding only to the litigation parties. GMC is not a party to the suit, and as such, the said order is not binding on the GMC. Noteworthy that no field verification report has been found with the record. Therefore, a field inquiry may be directed to be conducted upon the disputed construction plan. Regarding the demolition of the corporation, by my considered legal opinion is that in the reply submitted by Sri Bhavesh Chandra Kolita, he has not mentioned anything regarding the building permission, and he has also not submitted any documents in that regard. Moreover, on observation of the sale deed, it appears that the schedule does not have any details of the inside house, as alleged by Sri Bhavesh Kolita. Therefore, in my opinion, GMC may proceed to demolish the building after conducting a proper inquiry, verification of the land building in case if it is found to be constructed by not following the relevant building laws or without obtaining proper permission from the concerned authority. So, my lord, notice will be kindly issued to them. Why they are sitting tight?
Okay, heard Mr. Rajesh Sokiel and counsel for the petitioner. Mr. Nayak.
Lordship must have heard what my petitioner friend is submitting, Lordship.
Right.
Private respondent has constructed a house on a plot of land belongs to him, Lordship.
Yes.
If it is so, Lordship, why do you want us to demolish the house, Lordship? He himself should demolish.
How will he demolish?
If it is his own plot of land, Lordship.
How
You
can
must-
we? Because
No, no,
how
you
can
must-
we-
So he is submitting that the private respondent constructed a house on his plot of land.
a portion of the land.
Your law officer has opined. it
Law
should be
officer, Lordship,
demolished.
he has only given the half story, Lordship. Lordship may come to page 55. Law officer only given an opinion, Lordship, page 55. Lordship may come to the comment given by the zonal engineer. Middle portion. After proper demarcation of the land we may proceed for further course of action from our end in this regard. So that has been suppressed.
No, we have not suppressed anything.
And
No,
in-
where is
then-
that
You can,
journal engineer's
can-
report?
I have
Yes.
made this statement in
Lordship,
my
may
commission.
see the seal down below, Lord.
No, which page?
Last page, Lordship, page 55,
55.
handwritten.
Last paragraph.
Last but one, Lordship.
Hmm.
After proper demarcation of the land, we may proceed for further course of action from our end in this regard.
So
Lordship, in fact, the portion of land is a disputed one, Lordship, and the petitioner approached the deputy commissioner, wherein the deputy commissioner passed an order for demarcation of the land of the petitioner. The other side approached the revenue board, Lordship. Revenue board upheld that order.
No,
No.
dispute their appeal. Lordship,
Alright,
I have annexed-
you file your response.
Upheld that order means deputy commissioner's order.
Well, the
Third
order of the DC is not, yes,
Third learned
DC has
counsel
order for
appeal
demarcation,
is written-
and that order is upheld by the Board of Revenue.
returnable for weeks. Mr. Nayak appears on behalf of
1 and 2,
AMC.
Lord.
1 and 2.
Yes, Lord.
Steps on respondent 3 by registered post 80 as well as usual courts be taken within a period of 1 week. Respondents are at liberty to complete their instructions and file necessary affidavit. List accordingly.
My lord, there is a simple interim prayer that pending this case, the respondent number 3 may not further construct without the permission of the GMC on my land.
Let them file their response first. Notice on the interim prayer also.
The interim prayer may be
returnable on the
considered,
same day.
interim prayer may be considered next week, next time.
Next time, yes.
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 Obliged.
Please, Your Lordship, matter pertains to demolition notice issued by the commissioner on 7/2/2024, Lordship. Actually, Lordship, I am the co-owner of a plot of land with my sister and mother.
Hmm.
And after obtaining NOC from the mother and sister, I applied for building permission on 11/3/2003. Thereafter, I obtained NOC on 27/11/2004. And thereafter, after construction of the ground floor, the assessment has been done by the assessment ID number 41700025 is reflected in demand income notice, Lordship, annexure 524. Thereafter, again, for up to second floor, I applied for building permission on 27/12/2012. And thereafter, they have given me NOC for construction up to second floor on 24/2013. That is in annexure 6 to page 25, Lordship. Thereafter, after construction of the first floor, the assessment has been done by assessment ID number 217010482651. And after that, assessment first floor was constructed. Thereafter, I have on 6/2/2023, I have received a letter from the commissioner office for asking me approval and NOC regarding a complaint by respond number 4, Lordship. Thereafter, I filed my reply with all documents on 8/2/2023.
You are agreed by which notice?
I agree by Lordship annexure 15, page 37, Lordship.
Yes.
Yes, Lordship. Lordship, in this notice, Lordship, the commissioner has issued notice under section 337, Lordship, and as per GMC Act, Lordship, they cannot exercise their power after proper approval and NOC given by the authorities and after assessment of the construction, Lordship. It is reflected in GMC Act, Lordship.
Hmm.
337, section 337, page 131 of the GMC Act, Lordship.
Yes,
Yes, Lordship. Page 131 of the GMC Act, Lordship. Comments question, exercise of power. Power must be applied within a reasonable period within 3 years. Next, power to require removal and alteration of work. The power cannot be used in respect of a building constructed on the own land of a person after completion of the same and after assessed by the municipal authority. The power under section 337 must be utilized only within 3 years from the date of completion of the building, provided that the building has not been assessed by the municipal authority.
so now in response to this notice, what has been done?
So
Have you done?
they are repeatedly coming to demolish my under pressure. I have demolished my first portion of the house, Lordship. Even Lordship, the respondent number 4, I've filed a complaint before the authorities. They have not taken any action regarding that. I have annexed the photograph also, Lordship. In page 35 and 36, they have constructed the building over the staircase of the building over the wall. Lordship.
Now in the notice, that
Yes,
is
Lord.
37,
Yes,
you
Lord.
show us what is the violation. What is the violation?
337, Lordship, 337(3). The commissioner cannot act after 40. It is because the assessment has been done in the year 2014. Now this is 2024. As per the act, after 3 years of assessment, they cannot do that because I have approval and NOC and everything, Lordship.
You show us from the notice what has not been maintained.
Lordship, they have said that I have setback and Lordship number 1 schedule A, nature of construction of cantilever of first floor, inadequate setback
Where is the
maintained as per
violation,
building
Mr.
bylaw.
Bora, from the notice?
What notice is, what you will find the notice in page number 37. 2001 and 2 notice, madam. Basic contention of the petitioner is that the building NOC was given, the building was assessed, and in 2024 you might have give me the notice. And since 3 years has passed from the date of first assessment of that particular building, you cannot proceed because Lordship hold the same.
You are proceeding for demolition on what basis?
Demolition of basin because there is a violation of the setback. There is a complaint, there is a violation of the
Where
setback.
is the violation?
Lordship will find it schedule 1.
Lordship.
Schedule. Nature of the construction of cantilever of the first floor, inadequate setback maintained as per building. And these are the setbacks violations are same.
So where is the violation?
Approve is so, maintain is so.
Maintain is so.
There are violations.
There's
He admits there is a violation. He admits there is a violation, and only contention is that after 3 years of assessment, he will not be able to demolish man. Because there is a single bench decision that was overruled in the division bench decision, my lord.
Decision also, Lordship, for some small because there's only 0.5 meter, Lordship, deviation. If you see the Lordship schedule, Lordship, the approve is 1.5 meter and maintain is 1 meter. It means 0.5 meter deviation only. And another south portion 1.5 meter is approved and 1.25 meter setback has been maintained. That means 2.25 only deviation, Lordship. In this regard, Lordship, Supreme Court has said.
What about the other side, 5 meters?
No, 5 meters, nothing is mentioned, Lordship. And in west side, there is no deviation. West 0.454 has been approved and 54 has been maintained, Lordship.
Now that thing is matter. There is a division bench decision that if it is a assess in the assessment is done, there cannot be a stoppel for unauthorized construction. That had to go. But the deviation are 2 types of deviation. It is compoundable and non-compoundable. He says these divisions are compoundable. The moment he says that divisions are compoundable, he had filed an application under section 18A of the 2014 Act. It will be considered whether the compoundable deviation, he will get the compoundable part. He or she have to pay the penalty. Rest, if this is beyond the compoundable, that will have to be demolished. My lord, I will, if Lordship stands to the building bylaws, my lord, section 18A. As per 18A, my lord, he had to make an application, my lord.
All right. Have you filed any application for compounding?
No, I tried to file. They have not accepted. I have the copy, Lordship. They have not accepted the regulation regarding that. That's forwarded only. But they are repeatedly coming with police and all. They have not considered my this and they have not even taken action regarding my complaint against respondent number 4.
The record. Why have you not brought it on record?
Because it is not received by them, Lordship. Because only forwarded.
Not even a statement.
That's why, Lordship.
There is no. Is there no online portal for submission?
No, this had to be done by physically, my lord. Then an engineer will go Contract
Have-
calculation.
No,
has to-
somebody has to file an application.
That application have to
Adjournment is
file
that
another
is not-
section 18A, my lord.
They are not
No, but
accepting.
they're saying.
Lordship will direct, my lord, will accept and go
All
for
right,
it.
you accept it.
Lordship,
Heard learned counsel for the parties, the grievance of the petitioner is the attempt to demolish portion of a building in pursuance to the notification, notice dated 7/2/24
24, my lord.
issued by the GMC under section 337 within bracket 1 and 2. Stop. According to the learned counsel for the petitioner has not maintained the setback as per the approved plan, and therefore, to the extent of the violation, the GMC authorities have issued this notice
Notice.
for demolition of the illegal construction
Not
or unauthorized construction. Stop. Learned counsel for the petitioner submits that the assessment has been properly done, and after how many years? When was it done? 2014.
14, Lordship.
And therefore, after 10 years, there is no scope for making reassessment and issuing the notice for illegal construction. Stop. The further submission is that an application for the further submission is that there is a provision for compounding
The appendix 3, my lord.
compounding the
And that is the 18A is the permission there under section they have done. That's the appendix 3, my lord. The compoundable and non-compoundable portion, my lord.
submits that she had filed an application for compounding the defects. However, the said application was never accepted by the GMC authorities, and they are repeatedly forcing the petitioner, they are repeatedly harassing the petitioner, seeking to demolish the so-called illegal or unauthorized portion. So, para. Mr. S. Bora, learned counsel for the petitioner, submits that the claim of the writ petitioner that the assessment having been made in 2014 and no subsequent assessment can be done is not.
No, that is not my lord. Even if the assessment has been done, that cannot work as a stopper against the illegal construction.
That's right. So, therefore, as per
Lordship,
the
that is not
Petition of
correct,
Act, if
Lordship.
there is an allegation of, if there is any unauthorized or illegal construction, then the GMC authorities are duty bound to take necessary steps under the provisions of the Act. We, however, submits that there is a provision for compounding the defects subject to such application being filed by the petitioner, and the authorities will consider the matter in terms of the provisions, and if it can be compoundable, necessary orders, etc., will be passed by the authorities concerned. And accordingly, let notice be issued, returnable 4 weeks. Mr. S. Bora appears on behalf of 1, 2, 3 steps on respondent 4 by usual course and registered post within 1 week from today. The pendency of the writ petition will not act as a bar for the petitioner to file an application for seeking compoundation, seeking compounding of the defects alleged by the GMC authorities as per the notice dated, impugned notice dated
7/2/2024.
7/2/2024. So, in the event the petitioner files an application, then the authorities will consider the application as per provision of law and pass adequate and appropriate orders thereon. So, since the court is in session of the matter, let the GMC not take any steps towards demolition without leave of the court. The respondents are at liberty to file the necessary affidavit in the meantime. Matter be posted again on 7th of June.
In the meantime, he should file the blood application, because otherwise, if there is
We are giving them liberty. We'll see if they don't file, we'll pass other orders. Matter be
7,
listed.
2004 may not be, may not be demolished. or
No, attainable.
matter be
Maybe,
listed on
maybe
seventh,
advance law.
7th of June.
Must apply.
Return
Problem.
7 June. 7. Yes.
Procedural. Okay. In fact, my lord, we have lodged complaint that our land has been encroached and the road has been constructed upon our land. They have filed an affidavit, they said it is their, it is not, it is government land. So, my lord, to our, as per the sketch map, and we have also given reply, we have found that they have encroached our land also. So, my lord, may I pray to the, that Deputy Commissioner, you may lordship can give a direction to take care of the matter and inquiry may be caused and thereafter may be hearing both sides may take a decision. If they taken our land, then we are entitled compensation.
Let the circle officer file an independent neutral report considering the fact that they are disputed questions of fact in this matter. Their contention is that out of their 10 bighas of land, government has forcibly taken 3 bighas to construct a road. That is their contention.
You are appearing for which department?
Well, at PNRD, Panchayat.
Panchayat is constructing some road.
My lord,
Village road.
And according to the Panchayat department, there was already a government road existing. We are just improving the condition of that road. So because of that, they are disputed facts. So let the circle officer file a
Who's for the circle officer?
the revenue department.
Circle officer is not a party.
Secretary is not a party. Madam. Chief Executive Officer of Borpeta Jila Parishad is there. Deputy Commissioner is there, Borpeta.
Deputy commissioner is there.
Yes,
Which
Borpeta.
party?
Yes. That's number 3, madam.
Heard learned counsel for the party. The petitioner is aggrieved. Petitioners are aggrieved. Have approached this court with a grievance that in the land measuring 10 acres, 15 latches covered by tag number 144, patta number 4 of village Agdia Pathar, Moza, Oruketri, which belongs to the writ petition and has been mutated in their name. A portion of that land is being unauthorizedly used by the respondent authorities, unauthorizedly taken over by the respondent authorities without following due process for construction of a village road. Stop. The learned counsel for the petitioner submits that if the land is required to be acquired, then due process as per provision of law should have been initiated by the respondent authorities and thereafter the land could have been acquired. However, without considering the prayers of the writ petitioner, the authorities have proceeded to construct the road, acquiring a portion of their land covered by the said tag number, patta number. So the requests made by the petitioners have not been acceded to. So, Mr. P. Hendick, learned standing counsel PNRD on the other end submits that to the instructions received by the respondent, no such land belonging to the writ petitioner has been taken over for construction of the village road. So, who has filed the affidavit?
What the secretary?
Adjustment number 5.
What do you say?
My lord, as per my instruction, my lord, there is a public route, my lord. There, that particular route is using by the public. And my lord, for repairing that particular road, there is some earth cutting, my lord, from surrounding, my lord, land.
Page 3 of the affidavit.
My lord, in fact, my lord, there is some, my lord, earth cutting process was going on, my lord, nearby the road. Nearby the road, my lord. My lord, that's why, my lord, some damage has caused, my lord, as per my instruction, my lord.
Damage to the petitioner's land.
Land, my lord. My lord, what happened, my lord, there is a particular road. My lord, road, my lord, supposed to be repaired, my lord.
Mr. Learned Counsel appearing for the what is this?
513.
Panchayat.
513.
Appearing for the secretary of number 13 Pochim Koruketri Gaon Panchayat. Has filed an affidavit. Stop. On that basis, he submits that there is already an existing road, the village, which is required to be repaired, and in the process, some earth cutting had taken place, and some portion of the land may have been damaged, belonging to the rich in the process of construction of the road. Stop. Fair. The Deputy Commissioner Borpeta is the party respondent. Considering the disputes, considering the rival submissions made by the council, so this court is of the view that a report be called for from the Deputy Commissioner in respect of the claims made by the petitioner that portion of the land has been utilized without following the due procedure of law. Stop. The Deputy Commissioner will direct the circle officer, concerned circle officer, to make a field verification and thereafter file a report, and which report we place before the court by way of an affidavit. Stop. Let the entire exercise be completed within a period of 4 weeks. Further orders, if required, will be passed by the court on the basis of the report as directed to be placed before the court by the circle officer, by the DC in his affidavit. Let the affidavit also be filed within a period of 4 weeks. Matter be listed again after 4 weeks.
But it, on 24th of June, my lord.
3 weeks, make it 3 weeks. Matter be listed on 24th of June.
Obliged.
Yeah, please, Lordship. In this matter, affidavit will be filed during the course of the day.
Lordship, let it be fixed up sometime next week, Lordship, and the matter, because that was the.
Are you sure?
Yes, sir.
MSM Hazarika, Learned Senior Counsel, assisted by MS appears for the petitioner. MSS Burwa, Learned Government Advocate, submits that the affidavit required to be filed by the respondent will be filed during the course of the day. Stop. In view of such submissions, let the matter be listed on 30.
Yes.
30 June.
30 May.
Sorry, 30 May. Sorry, 30 May. By which time the respondents will file the affidavit as submitted in court. '22 is also similar. Similar. Yes. Same order. None appears for the petitioner on call. Matter be listed next week. MSS Burwa appears for the respondent. You're appearing on 23?
May I please, your lordship? Lordship, in this case, all the pleadings completely lodged. Lordship, before taking to the merit of the case, I'd like to draw your lordship kind attention the order 5/1/2024, a detailed order passed by this honorable court, certain observation made on that date, my lord. 5/1/24.
Yes.
Lordship, give permission, I'd like to read this order, my lord, from
Please.
second paragraph. It is the specific case of the petitioners that their parcels of the land measuring 2 big of 14 katas of 12 letters covered by duct number so and so, so and so, so and so, were requisition by the Deputy Commissioner Kasar on 26/11/1964 by requisition case number so and so, on the ground that the said parcel of land were required for maintaining supplies and services of the essential to the life to the community with establishment A headquarter BSF at Katigora, Silchar subdivision, exercising power under Section 3(1) of the Assam Land Requisition Act 1964. After taking possession of the requisition land, the parcels of the land were handed over to the respondent authorities in the Union of India. It further demonstrates that the land acquisition proceeding was initiated by the Deputy Commissioner Kasar by LA case number 6, 2002 and 2003 for acquisition of the said parcel of the land by issuance of the notification under Section 4 of the 1994 Act. In the said notification, the petitioner's parcel of land were mentioned for acquisition. It was only on 21/6/2013 the declaration under Section 6 of the Land Acquisition Act was found to have been issued. From the stand taken by the respondent authorities in the Union of India in their affidavit in opposition, it revealed that Deputy Commissioner Kasar estimated the amount of compensation for acquisition of the entire parcel of land sought to be acquired by LA case number rupees 6,36,665. It has been also been stated by the respondent authorities in the Union of India that a set amount of rupees was deposited by the Deputy Commissioner. This is very important, my lord. The said amount was deposited by the Deputy Commissioner Kasar Silchar on 8/4/2008. The petitioner have stated that they were neither made aware of any award under Land Acquisition Act 1894, nor they had been paid any compensation against any land acquisition process initiated by the LA case number Central. From the stand taken by the respondent PWD, Assam, in the affidavit in opposition, it revealed that the parcels of land purportedly belonging to the petitioners were handed over later on by the Deputy Commissioner Kasar Silchar to the PWD, Assam, for the purpose of construction of road with the assistance of the 112 RCC GREF on 16/12/2024. In this petition, the petitioner with the above facts have contended that during the period within which the parcels of land were under requisition from 19/1/2004 onwards, the petitioner has received the last requisition rent only on 5/2005, and the memo disbursing requisition rent did not also disclose the period. Subsequently, 5/2005, the petitioner did not receive any requisition rent till date. From the above concept of the fact, it appears the prima facie that the parcels of the land the petitioners mentioned above have not been acquired by following any valid process of acquisition as the respondent. Till date, have not brought anything on record as regards culmination of the land acquisition process initiated by LA case number Swencha under the Land Acquisition Act, since an amount of rupees Swencha stated to have been deposited by the respondent authorities in the Union of India, and the said amount has not been disbursed by the Deputy Commissioner Kasar to the petitioner till date. It is not possible for this court at this stage to arrive at any final opinion. The three separate counter affidavits were filed on behalf of the respondent 178 and respondent 5 and 6 for the purpose of finding out the real state of affairs. At the counter affidavit from the ants, the respondents number 2, 3, 4 are extremely necessary considering the facts that petitioner's parcel of land, which are admittedly periodic patta land, found utilized by the respondent authorities in the Union of India and state of Assam since 1964 continuously. My lord, after this order, my lord, here, my lord, respondent, my lord, particularly 2, 3 forest file affidavit, my lord, is a very surprise, my lord. They have denied. The no such amount has been ever been deposited by the union to them. And accordingly, the union also counter replied in this case, they have deposited. Now the I am become the football here in this case. They have one post kicking a ball to me and another.
What is the stand in the affidavit by?
Yes, my lord. My lord, can you have a look the affidavit stand of the union first? Paragraph 10, 12, and 13, important. Page 41, my lord, in the affidavit.
Additional affidavit or affidavit?
My affidavit, additional come letter, my lord. This is the first affidavit.
Affidavit by respondent 1.
1788, Union.
178.
Respondent 63 affidavit.
No,
Wait, wait, wait.
we didn't do
Yes.
My lord. Paragraph 10. That with regard to the statement made in paragraph 8 of the writ petition, deponent denies the same. Further, deponent begs to state the land acquisition amount of rupees so as projected by the DC Kasar has already been deposited with the land acquisition collector Kasar district number byte 97 R16 letter number so 8 April 2008. Presently, this land is held with the state PWD Silchar NH division with effect from 16 December 2014 with all the assets on this land. Any further disposal of the land rests with the State PWD Silchar Assam being a present caretaker. That with regard to the statement made paragraph 9 and 10 of the petition, deponent does not offer any comment. The deponent states that presently this land is held with state of PWD Silchar, 12 my lord. With regard to the statement made in paragraph 11 of the petition, deponent denies the same. The department has already paid the compensation amount as projected by the DC Cursor. Presently, this land is held with the PWD. Finally, paragraph 13 my lord. That with regards to the statement made in paragraph 12 of the writ petition, deponent denies the same. The deponent has already paid the compensation amount as projected by DC. The landowners not submitted their willingness for further extent of lease agreement. Presently, this land is held with this PWD Silchar Center. This is the final. That means they have deposited this compensation amount to the concerned Deputy Commissioner Kasar, my lord. Now, my lord, one annexure they have enclosed at page 46, annexure B. This is a letter written by the Deputy Commissioner on 2/8/2002 to the official commanding. Finally, my lord, at page 50, the amount they deposited is acknowledgement, my lord, at page 50. Then 8 April 2008. There's a final letter from the
page
50, my lord, annexure D. Acquisition of so number 1, my lord. Your reference letter number 2nd August 2002, and our letter number number 2, my lord. SBI Silchar check number dated 6 April 6,36,665 on account of land compensation in respect of submitted land disclosed herein. That means from this the document is disclosed that they have the Union Authority has deposited this amount before the Deputy Commissioner. Now, my lord, the very surprise your lordship will get, my lord, the Deputy Commissioner, my lord, has taken stand here. Absolutely denied, my lord. Page 68, the affidavit filed by the respondent 3-4. Para 7, 8, and 11. Page 68 and relevant paragraphs, page 70, my lord.
Yes.
Para 7. With regard to statements made in paragraph 6 of the instant petition, the opponent begs to state that the compensation to the pattadar could not be paid, my lord, as the requiring department did not deposit the estimated amount at the disposal of the collector. This is the first stand. Number 8, my lord. That with regards to statement made in paragraph 7 of the instant petition are the matter of fact. The deponent further begs to state that on receipt of the communication for the petitioner, the BRTF authority has communicated by letter number dated 4/8/2014, but no response from the regarding department is received. Finally, paragraph 11, my lord. That with regard to the statement made in paragraph 11 of the instant petition are not a matter of fact, and the deponent begs to state that the letter dated 7/12/20 as stated by the petitioner, is not found to have been received by this office. That means they have denied that no such, the union has stated they have deposited 6,36,665 to them, my lord, Deputy Commissioner Dasar. They have denied no such amount has been deposited to them by the authority. And in counter, and the stand taken by Deputy Commissioner, union has again filed one additional affidavit, my lord.
Which letter they have not received? 712?
That is annexure 12 of my writ petition, my lord. I'll take your lordship letter, my lord. The additional affidavit filed by the union again,
Okay,
my
so
lord.
let us hear the matter.
Yes,
Mr.
my
Dex will hear the matter.
Lord, it's
But
not- it's not-
union, why don't you give us the evidence of how the payment was made?
Malad, by check, Malad, check number is there, Malad, in the page 83, Malad. SBI Silchar check number 0003.
No, from your account,
Yes, Malad.
when was the check encashed? Give us the details.
Yes.
And by whom? Which account it has gone?
Yes.
Not a
Give us
big
all the
grant,
details.
not compensation, not vacating my land, my lord.
When can you give it?
Malad, some time may be given, but
No, since the state has denied,
yes, Malad.
you may have deposited,
Yeah.
but since the state has denied that we have not received or money not deposited, you show us from the account that it was deducted.
Yes.
Yes.
You show us that detail.
Malad, second week of June, Malad.
All right, we'll have it on 18th.
Yes.
My lord. My lord.
18 June. 18 June. Heard learned counsel for the parties. The grievance of the petitioner is in respect of non-receipt of the compensation amount for acquisition of the land by the. You are representing whom?
1, 7, and 8.
By the GREF. Do you call it BRO?
BRO.
By the Border Roads Organization. So the learned counsel for the petitioner has referred to the averments made by in the affidavit filed on behalf of GRO that the amount of compensation has already been deposited and is in the custody of the respondent number 3, namely the Deputy Commissioner cum Collector of Kachar. Stop. However, the affidavit filed with the DC reflects that they are not in receipt of the amount. Accordingly, the respondent DRO will place before the court the particulars of the disbursement of the amount and the particulars relating to the disbursement of the amount into the account of the respondent number 3, i.e. the collector, as stated in their affidavit. The parties are agreed that the matter be listed again 18th of June.
This petition has been filed for a correction of revenue record. The petitioners and their petitioners' fathers are the land owners, not possessors of land more than 21 acres. And they were occupying land under the jamidaries of Gauripur relatives. Subsequently, some evictions order has been passed in way back of 1986 relatives. Subsequently, they have filed a title suit confirming their right title, interest, and possession of the land relatives. That had been order dated 27/8/1991 and decree dated 6/9/1991. The right title and possession has been conferred upon the petitioner. That is in favor of the petitioner, your lordships. The decree, your lordships, page 21, your lordships, judgment and decree. The decree, your lordships, page 22. There is a two scheduled plot of land. 21.
Now that judgment has attained finality. Judgment and degree.
Then they have approached before the respondent authorities numerous times, your lordships, but they have been denied on the pretext that they were filed an appeal. though the power conferred upon the deputy commissioner under the provision of 53A, upon on a receipt of any information, the deputy commissioner have a direction given to the authorities to correct the revenue record. There is no power, Your Lordship. But till then, Your Lordship, no revenue record has been corrected. But after filing the repetition, they have come out their response, Your Lordships. They annexed one Jamanmandi, but they have not denied our possession or any settlement in by holding the land over a period of time, Your Lordships. The thing is that in the annexes they have shown that the repetition are having some acquired land along with his brother, but not over the land which has been decreed in favor of the repetitioner along with their brothers, Your Lordship. Your Lordship, no actions have been taken till date, Your Lordship, for correction of that portion of the land in favor of the repetitioner along with his brother conferred by the Learned Municipal Court, Dhupuri, Your Lordship, till date, Your Lordship. They never negated our possessory right till date by way of their never denied our possession also in their affidavit also. That is the parallelisms for correction of the revenue record, Your Lordship, in terms of the order passed by this learned court below, Your Lordship. And since they are possessing over land,
Yes.
but they are never disputed about possession either in the repetition affidavit opposition or they are in the trial court below, Your Lordship. Since the judgment and decree is still subsist in our favor, the petitioner have a right to claim about the correction of revenue record in terms of the land and revenue regulations, Assam land and revenue regulations. More particularly, 53A, Your Lordship. It speaks itself, Your Lordship.
Yes, respondents, who's there? Mr. Burwan? There is an averment in your affidavit, para 6, page 39, that they have never approached.
They haven't.
Whereas their claim is that they had approached and it has not been corrected.
Yes, so we have denied that.
No, they have not denied. Paragraph number 5, they have offered no comments. Paragraph number 3.
No, page
Page
para 6,
39.
para 6 of their counter affidavit.
There is no record of the petitioner having approached the present respondent to correct the land record as per decree passed by the is more than 30 years old. But I have annexed one representations, annexed 2, page 36.
You approach them again now. We'll direct them.
Lots of
Heard learning counsel for the parties. This petition is filed by the petitioners, praying for a direction to correct the name of the writ petitioner in the record of rights in terms of a judgment and decree passed by the court of
Municipal number 3 at Dhuburi.
court of civil court of Munsif number 3 at Dhubri. In Dhubri. Stop. It is the submission of the counsel for the petitioner. You are the plaintiff or
I'm the plaintiff, one of the plaintiff.
that your father was a plaintiff. Or you,
I'm also under the plaintiff.
the petitioner along with his
Brothers
are plaintiffs in the suit, and the suit is for declaration of right, title, and interest, and for correction of records of rights within confirmation of possession. Stop. The suit was decreed on contest, declaring that the plaintiffs have the right, title, and interest and correction of record of rights over the suit land. And the suit land is decreed. The suit is decreed without cost. Stop. The schedule of the land is also specified therein. Stop. Pursuant to the decree, judgment and decree, the petitioners approached the respondent number 3 for correction of the record of rights. Stop. However, the same was not corrected by the respondents on the pretext that some appeal has been filed with the government. So upon making necessary inquiries, it is found that no such appeal has been filed by any party. The judgment and decree has in the meantime attained finality. Stop. Pursuant to issuance, pursuant to issuance of notice, the circle officer Dhubri has filed an affidavit where at para 6 there is an averment that there is no record of the petitioner having approached the circle officer to correct the land record as per the decree passed in title suit number 25 of 1989, as the decree is more than 30 years old. Stop. The petitioner has reiterated his stand in the writ petition by filing a reply affidavit. Stop. In view of such categorical averments made in the affidavit, this court is of the view that the claim of the petitioner having been decreed by the competent court of civil jurisdiction, the authorities are required to examine and the grievances of the writ petitioner and pass necessary orders thereon. Under such circumstances, the petitioner will approach the respondent number 3, namely the circle officer Dhubri, for correction of their names in the record of right in respect of the scheduled land as mentioned in the judgment and order district so and so in title suit number so and so, and the respondent number 3 thereupon will proceed to examine and if required cause field verification. Will thereafter proceed to make necessary corrections in the record of right in terms of the decree, judgment and decree passed by the competent civil court in title suit number so and so by the judgment and order dated so and so. The petitioner will approach the respondent number 3 within a period of 2 weeks from the date of receipt of a certified copy of this order by filing a copy of the same along with other relevant documents including the judgment and copy of the judgment and decree dated so and so passed in title suit number so and so. The respondent 3 will thereafter take all steps necessary for due correction of the name of the writ petitioner. So the entire exercise will be completed within a further period of 60 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed of in terms of the above. Yeah.
Wait, please, your lordship, we'll file our affidavit in the next week, lordship. We seek 1 week's time.
Madam,
Yes, madam.
any objections to the
No,
primary?
madam. Let them file application, madam. After 2
MS.
weeks, madam. That may be taken after 2 weeks. madam.
Yes. MSS Borpatru Gohai, Learned Counsel, appears for the petitioner. Mr. I. Botakur, Learned Counsel, appearing for Forest.
Forest Department.
Forest Department submits that they would like to file the affidavit. Have you received the instructions?
Lordship, it was about producing the confiscation proceedings. We have received it, lordship.
Has received instructions, would like to file the affidavit by next week. So accordingly, matter be listed after 2 weeks. It is expected that the affidavit of the Forest Department should be on record by the next 8 weeks. Yes, after 2 weeks.
Right.
You want a fixed date?
No, madam.
All right.
Objection. My lord, sorry to interrupt, my lord. The interim order may be continued. my lord.
Interim order passed earlier will continue.
That's right.
Yes.
But as per the last order, it is 29/4/24. A record was produced by the phone number 10.
Can it be taken about Tuesday?
Thursday.
Thursday.
The request of learned government council that deferred be taken up on 20. On 30. 30. Mr. M. K. Sharma appears for the petitioner. Mr. C. K. S. Borua appears for 5. M. S. Bora for.
I'm appearing for 3 and 4.
Mr. S. Borua for
3 and 4.
3 and 4. M. S. Bora for G. Azariga, sorry, for 1 and 2.
Obliged.
For 28 become interest.
There's a caveat. Who's filed the caveat?
Lordship on the last occasion also Lordship.
All right. It is submitted by the learned counsel.
One
to the-
observation may be necessary because when the.
He says it is infractuous.
No, my lord, may not be, because when the interim order was passed.
No, but it is his call to decide, pursue the matter. He says it is infractuous.
Huh? Yes, sir.
Submits that the writ petition has become infractuous, therefore does not wish to press the writ petition any further. Accordingly, the writ petition stands dismissed as not pressed. Mr. S. Talukdar, S.K. Talukdar appears for cooperation.
My lord.
Caveat number so and so. Accordingly, none appears for the caveat. But in view of the order passed, caveat stands discharged.
Interim order stands vacated.
Interim order, if any, stands vacated.
By this reason, we have challenged the impugn order dated 16/12/2022. This court had order dated 1/2/2023 passed the order of status quo and directed Mr. K. Gogoi to obtain some instruction.
Yes.
This impugn order was passed without giving opportunity
Where is Mr. K. Gogoi? Who's for the railways? Anyone for the railways? There is there is a status quo order.
Lordship.
All right. Mr.
A.
A.
J. Hajori.
A. J. Hajorika, learned counsel appears for the writ petitioner, none appears for the respondent. Railways. Stop. Matter be listed after 1 week. Interim order passed earlier on 1/2/2023 stands extended.
I do.
In this case, I'm appealing for the GST department. I received instruction. I required some time to file my appeal. Is in the
Mr.
order?
KL prays for further time to file these affidavits. MS
M. Nirola, Lordship.
M. Nirola, learned counsel appears for the petitioner. Matter be listed after
2 weeks.
2 weeks. Interim order passed earlier will continue.
Macho.
Matter be listed again on 14th. 14th of June.
That's
Yeah,
Yes, your lord.
I was directed in the instruction from the department, correspondent board, and as per instruction, my lord, Aadhaar has been generated, my lord.
Generated.
Yes, ma'am. Only before the filing of this petition, my lord.
Oh,
21 in the year. At 7:21.
Mr. P.S. Bhattacharya, Learned Council, DGC, has produced a copy of the instruction received from the Unique Identification Authority of India, which is like a UIDAI, Regional Office, Guwahati. To submit that as per the record, petitioner's Aadhaar has already been generated on 5/7/2021 with the EID numbers when dated. The petitioner can download the Aadhaar, e-Aadhaar against his EID numbers. So, copy of this instruction is furnished to the council for the petitioner. Mr. Chakma.
Yes, Ketchup.
Yes, Mr. Chakma, Learned Council to the petitioner submits that in view of the instructions received, no further cause survive. Pursue the petition.
Your Lordship, let me take instruction whether the petitioner received further further.
He is not supposed to receive, he is supposed to download.
Yes,
What
ma'am.
more do you want?
Before filing the petition, Aadhaar already been generated, ma'am. Misleading, ma'am.
The petition according to instructions and the same stand dismissed as not read. As in practice.
Keep over.
Yeah, please, my lord, this may not relates to non-payment of bills of salary. And, you know, affidavit was filed on behalf of restaurant number 4, my lord, on 22/5/2004. Yeah, perhaps it is not on record, my lord. I have checked it in morning, my lord. Affidavit.
Sorry, come back again. Your submissions.
My lord, this matter relates
Some
to.
affidavit has to be filed.
Yes, my lord. It is not on record, my lord.
Has it been filed?
Yes, ma'am.
In terms of the earlier order dated 9/4/2024, affidavit on behalf of the government has been filed and a copy thereof has been served to the Learned Council for the petitioner. However, the office note, sorry, however, the same is not available on record. Registry to trace out the affidavit stated to have been filed by the, by whom?
On behalf of restaurant number 4.
On behalf of the respondent number 4, on which date?
On 22/5.
On 22/5, and connect the same to the case record and list it after 1 week.
This may takes, my lord.
1 week, you want to file reply?
No, my lord. It is admitted.
We listed after we listed on 12th of June. 12th of June.
Please, Lordship. The item has become infructuous.
Learned Council for the petitioner submits that the writ petition has become infructuous. Accordingly, the same stands dismissed as infructuous. The interim order, if any, stands vacated. Mr. P.N. Sharma for elementary education, Mr. Bhattakur for forest, Mr. N. Goswami for what is 3 and 4? Deputy Commissioner Rao and Deputy Commissioner Sunitpur. Dismissed. Yes.
Please, Your Lordship, I'm appearing on behalf of respondent 1 to 4. Affidavit is ready, but we will be going to file it today.
Yes.
There are two occasions, Lordship, they have granted opportunity, but if it is yet to be
They're
filed.
filing it
But
today.
our
Yes,
prayer
sir.
is a very much simple, Lordship, as per the notification issued by the appropriate state government.
No,
Lordship.
they want to
We
file
are
it
paying-
today, let the affidavit be filed. Because there is a liberty granted as per the earlier order that the affidavit is to be filed.
Yeah, today they have failing to file, Lordship.
MS so Learned Council appearing for the
Respondent 1 to 4 on behalf of RK Talukdar.
respondent 1 to 4
Yes, Lordship.
submits that the affidavit is ready and the same will be filed during the course of the day.
Yes.
Stop. Mr. M. Soikia appears for the writ petitioner. Accordingly, in view of the statement made by the council for the respondents 1, 2, 3, 4, matter stands deferred to be listed again after 2 weeks.
Let me tell you.
17th, sorry,
Hi.
19th.
Highly obliged.
Obliged, sir.
Please, your lordship, the SLP filed by,
That same order.
yes, lordship, that will have a bearing in this case.
So you
Because,
want the same order?
yes, lordship,
Karipuri at order Nitu.
for,
Do you have a
before.
copy of that order? No.
no, lordship,
All right. When was the matter listed?
a day before,
Day before. Do you have the number of the matter?
yes, my lord, it was writ petition number 7.
Give us the name of the party, if you remember.
Rajendra Kumar Mangla, writ petition civil 1719/23. Rajendra Kumar Mangla.
It was listed on 22nd.
Yes, my lord, day before.
All right. Same order.
2 interim orders are here.
I think it fixed on July, sometime in July.
Yes.
All right. We'll pass the same order.
If it can go a little later, lordship, because that date is 25th
But
July.
those matters are listed. Let these
Yes.
matters be listed along with those matters
Yes.
on 22nd or 25th July, whatever date is there.
25th July.
Eh? Okay.
Interim orders shall continue.
Yes. Same order will pass.
Yes,
Yes.
Mr. Blake.
Item, this is 36, 37. 22nd or that I another, show me the order. Same order.
But in this case, delivery is ready, Lord. We will find it within 10 days.
You'll file it within 10 days.
Lord, somehow it is not filed, Lord. It is otherwise ready, Lord.
File it by next week.
Lord. Sorry.
Learned government advocate, Mr. N. Goswami, submits that the affidavit will be filed by next week. Prayer made is not objected to by the learned counsel for the petitioner. And Mr. H. Mukhtar appears for the you have filed. Respondent number 5, who submits that an affidavit has already been filed. Let the matter be listed again after 1 week, by which time the affidavits of the government may be filed as submitted. Yes.
May I please, your lordship. In this petition, lordship, we have challenged the order dated 7th of September 2021, lordship, by which the petitioner was removed from the post of a ward member, lordship. That is at page number 28, lordship. Page number 28.
28.
28, lordship. May I read it?
Yes.
Whereas public allegation received against Nasima Begum
so and so ward number 6 of North Karimganj CP under North Karimganj Development Block transfers that she has been having more than 2 living children. And whereas the said GP ward member filed mandatory affidavit at the time of filing nomination paper requires as per Rule 62 Roman 1A of the Assam Panchayat Constitution Rules 2018, declaring that she did not have more than 2 living children. And whereas the inquiry conducted in the aforesaid public allegation and report submitted by the BDO so and so in his letter dated so and so as communicated by the CEO Karimganj in his letter so and so substantiate that the aforementioned GP ward member has been having 3 living children since prior to filing her aforesaid mandatory affidavit. And whereas the examination of the government of the affair in its entirety has established beyond any doubt that the aforementioned GP ward member Nasima Begum committed fraud and filed fraudulent affidavit with ulterior motive to deceive and mislead the authority in violation of Rule 62 Roman 1A of the Assam Panchayat Amended Rules 2018 and liable to be removed. Therefore, I so and so by dint of power vested in me under Rule 62 1A of the Assam Panchayat Constitution Amendment Rules 2018 do hereby remove Srimati Nasima Begum from the post of GP ward member of so and so as required under section so and so for committing suppression of material facts and got elected currently as well. But my humble submission is that, Lordship, this Rule 62 1A of the Assam Panchayat.
Where is that amended rule?
Yes, Lordship.
Why don't you bring it on record?
Last occasion, Lordship, I have submitted the rule.
No, it should have been a part of the record. Where is the amendment?
These are the 2 gazette notification, Lordship, I have placed, Lordship.
Please read.
Lordship may kindly take up the first gazette notification, 19th March 2018, Lordship. Lordship may kindly come to amendment of section 111. Next page. This is the gazette notification dated, Lordship, the 19th March 2018, Lordship. Amendment of section 111. In the Principal Act, section 111, the existing provision shall be renumbered as section 111 within bracket 1, and thereafter the following new subsection 2 shall be inserted, namely, no person shall be elected or co-opted and remain as president, vice president, or member of Jilla Parishad, Anchalik Panchayat, and Gaon Panchayat who has more than 2 living children from a single or multiple parents. Now, Lordship, that proviso is important, Lordship. Provided that this provision shall not be applicable in respect of those persons who have more than 2 children prior to commencement of this act. Now, Lordship, may kindly take up the second gazette notification, that is 1st November 2018, Lordship.
1st November?
1st November 2018, Lordship, the second one, Lordship.
Yes.
Insertion of section 62. These rules may be called the Assam Panchayat Constitution Amendment Rules 2018. Now, Lordship may kindly come to 62. Condition and procedure for disqualification under subsection 2 of section 111 of the Act. Subject to the provision of the Act, at the time of filing of nominations, candidate shall furnish affidavit that she has not more than 2 living children from a single or multiple parents, that the state government concerned district authority shall remove any president, vice president, or member of Jilla Parishad, Anchalik Panchayat, and Gaon Panchayat if he or she is having 2 or more than 2 children from a single or multiple partners prior to the date of commencement of the Act, that is 19/3/2018, and gives birth to an additional child. Lordship, the relevant date would be, Lordship, 19/3/2018, Lordship. And Lordship, if any person, Lordship, who is having more than 2 children, that is, Lordship, after 19/3/2018, Lordship, then only, Lordship, he can be removed. Here in the present case, Lordship, the petitioner is a mother of 4 children, Lordship. And the last children was born to the petitioner on 19/9/2017.
Yes, then
Lordship may kindly come to page number 40, Lordship. I have filed one additional affidavit.
so what is the meaning of this now?
Although Lordship, the term has already gone, Lordship, but if the removal order remains, Lordship, then it would create trouble for me, Lordship.
No, first explain on which date this is applicable. What is the act says?
Yes, Lordship.
Not more than 2 children prior to commencement of the act.
Yes, Lordship. Act says, Lordship,
No, it
provided
cannot
that
be applicable to those who has more than 2 children prior to commencement of the act.
prior to commencement of the act, that is 19/3/2018, and gives birth to an additional children thereafter. If he or she is having 2 or more than 2 children from a single or multiple partners prior to date of commencement of the act, Lordship, he may have 2 or more than 2 children prior to the date of commencement. And Lordship, if he gives birth to an additional children, that is after 19/3/2018, then Lordship, this will be applicable in case of him.
Now, in your case, what is happened?
In my case, Lordship, I am the mother of 4 children, Lordship, and all the 4 children were born, Lordship, before 2017, Lordship. The last one was born, Lordship, on.
In your affidavit before at the time of
Yes,
filing
Lordship.
nomination, what did you say?
Yes, Lordship. Lordship may kindly take up my additional affidavit, Lordship. Page number 41. It starts from page number 40. Relevant would be, Lordship, page number 41.
Yes.
41, Lordship. Close F, Lordship. I do not have more than 2 living children from a single multiple partners as per the meaning of the provision under section 1112A of the Assam Panchayat Act 1994 as amended up to date and rules framed thereunder.
No, this is a contradictory statement. What is the
Lordship,
meaning of this? Why didn't you write that I have 4 children, but they were born prior to the provision of the act?
yes, Lordship, it is there, Lordship. So far as the language is concerned, Lordship, it is confusing a bit, Lordship.
Why?
I
Why
have-
are you writing confusing language?
I have written here, Lordship, I do not have more than 2 children in terms of the meaning of that particular section.
You are supposed to declare how many children
Yes,
you
Lordship.
have. This
No,
is an
Lordship,
affidavit on oath.
Lordship may kindly come to page number 40, Lordship, for a moment.
Huh.
Clause number 3, Lordship.
Hmm.
In this connection with my candidature for the above, I am submitting the information below as required in connection with subsection 1 and subsection 2 of subsection 111 of Assam Panchayat Act 1994. Lordship, although Lordship, it would have been better, Lordship, had I been mentioned all the name of my 4 children along with the date of birth, Lordship. But Lordship, I have not stated here, Lordship, that Lordship, I am the mother of 4 children. It is there, Lordship, but at the same point of time, I have stated that I do not have more than 2 children in terms of meaning of this particular section, Lordship. In a similar circumstances, Lordship, where same affidavit was submitted by the same Zilla Parishad, Lordship, another member was removed, and she had approached this honorable court, Lordship, and that I have annexed the order, Lordship, that is at page number 44, 13/3/2023. Same ground, everything same, Lordship. Affidavit was also same, Lordship. Same, Lordship. Page number 44, by which that writ petition was disposed of. Paragraph 6, 7, 8, 9, 10 would be relevant, Lordship.
Okay, we'll come back at 2.
Paragraph number 6, Lordship. May I read it, Lordship? After hearing the submission of the learned counsel for the parties, I find that a ward member can be disqualified and or removed from office on the ground of contravention of the provision of section 111 of the Assam Panchayat Act 1994 as amended, if he or she had more than 2 living children. However, the said provision admittedly would not be applicable in case of the petitioner, since all her children were born prior to coming into force of the amended provision of the Act. If that be so, there can be no doubt about the fact that petitioner could not have been removed from the office due to contravention of Section 111 of the Amended Act 1994. This brings the court to the next issue as to whether any penal action could be initiated against the petitioner for swearing a false affidavit. There is no serious dispute about the fact that affidavit shown by the petitioner at the time of submitting her nomination was false. The explanation submitted by the petitioner's counsel is that the effect of nomination paper was filled in by someone else and the petitioner had merely put her signature. The said explanation of the petitioner's counsel is, however, found to be wholly unacceptable. The petitioner could not have put her signature in an affidavit without going through the content of the same. If that be so, the petitioner would be liable to face legal consequences for swearing false affidavit. However, it appears that there is no provision in the Act of 1994 to remove a ward member from the office for swearing a false affidavit. It may, however, be permissible under the law to call in question the legality and validity of the election of the petitioner as a member of the Gaon Panchayat for submitting false affidavit. Rule 62(1)A of the Assam Panchayat Constitution Amendment Rules 2018 invoked by the respondent number 3 while issuing the impugned order dated so and so apparently deals with the requirement of
Now, your term is already over.
Yes, sir.
What effect, what benefit I get?
Lordship, suppose this order remains, Lordship. In the coming election, Lordship, I would not be able to contest
Coming
the
election, you tell it?
as because Lordship, this order, as per this orders, Lordship, it says that Lordship, I am having more than 2 children.
Assuming we set aside this order, what benefit will you get?
Lordship, in the next election, I would be able to
Next
participate.
election you apply, who knows in the next, when is the next
As
election?
because Lordship, this order will remain, Lordship, as because I have been ousted from my office, Lordship, on the ground that Lordship, I am having more than 2 children. Admittedly, that is not the position, Lordship. And Lordship, the power under which the authority has exercised power, that is not applicable in my case, Lordship.
Where is the impugned order?
Impugned order, Lordship, page number 28, Annex 4, Lordship. Annex 4, page number 28. Last paragraph, Lordship. Here, Lordship, the power was exercised under Rule 62(1)A of the Assam Panchayat Constitution Amendment Rules in 2018. Lordship. And this is not applicable in my case, Lordship.
Yes, what do you say?
The impugned order, Lordship, the impugned order was because he has filed out false affidavit, Lordship. Paragraph 4, Lordship. Paragraph 4 of the impugned order, Lordship.
Yes.
And whereas the examination of the affair of the entirety has established beyond and any doubt that the aforementioned DP ward member Nasima Begum committed fraud. And while
No. First, let us understand the affidavit she has filed.
Lordship.
Affidavit does not say that she does not have 4 children or anything like that. She's put it very cryptically.
Yes, sir.
Can it be understood to be a false affidavit? Can it be understood to be a false affidavit?
In the reply also, case Stoker's reply, page 25, Lordship. The reply also he did in paragraph, second paragraph,
Reply where?
page 25 of the resolution, Lordship.
25.
Yes, second paragraph, that's while filing the nomination as per procedure prescribed, I have stated on oath in the affidavit that I do not have more than 2 living children from single multiple partner as per the meaning of the term.
And what is the provision for swearing false affidavit? What is the consequence? Assuming.
Lordship, if we go by the Assam Panchayat Act, Lordship, there is no provision as such. But Lordship, there is a provision in the Assam Panchayat Act, Lordship, Constitution Amendment.
Yes. Can you pass the matter? Because Miller has to meet the assignment. Language is the applicant. As for the meaning of it. So as for the meaning, you see that he has more than 2 children prior to the date of commitment. Is 19. So only prior to the date of date that or to take dependent by the right.
How can there be an independent inquiry?
Verify whether yes, the fight is like changing my sector of the right. Not that is attached to the car.
There's a finding.
Yes, Lordship. The stigma that if that goes, Lordship, then my purpose would be served.
Okay. We'll have it on. We'll have it on 28th. Road. It's on 28th.
Highly obliged.
It's on 28th. February 28th. Yes.
May it please the Lord. My Lord, while mentioning, I virtually argued the case. 27th was the day, my Lord, when on that fateful day, because of the incessant rain, the program had to be rescheduled to tomorrow. So accordingly, my Lords, we applied for the permission, and permission has been declined on the ground at page 26. Seen and peruse the report submitted by officer in charge Azara Police Station, dated so-and-so regarding a written petition of Jintu Sharma, General Secretary, Dharapur Anchalik Rongali Bihu Konmilan, requesting permission for organizing cultural program of Jubin Garg on 25/5/24, where it has been highlighted that same event was previously scheduled on 27/4/24, and permission for the same was accorded by memo dated so-and-so. But same could not be organized as the pandal for the program collapsed on account of stormy weather. Moreover, a law and order situation arose on the scheduled day where miscreants who had come for the program indulged in vandalism and also assaulted on the on-duty police personnel, as a result of which as many as 11 police personnel had sustained injuries. In this regard, Azara PS case number so-and-so has already been registered and 8 persons have been arrested and forwarded to judicial custody, and another 13 persons have been served notice upon section 41A of the CRPC. In view above, permission for the cultural program is hereby denied. My Lord, I may be permitted to place an order of the trial court, my Lord, in connection with the case which they are referring to. Apparently, my Lord, the OC has given an adverse report. That is why, my Lord, the permission has been declined. Please come to this page 13, my Lord. Now, this is the case they are referring. They say that they have registered one case, 28/4/24. Accused persons, namely Ankur Kolita, Dhitisman Kolita, Biplab Kolita, Manas Das, Mukut Kolita, Anupam Kolita, Bhaskar Jyoti Kolita, and Dhrubajyoti Kolita are produced before me by IO after being arrested in with the instant case. I have seen and perused the forwarding report, the arrest memo, inspection memo, etc. The medical report of the accused states
that all the accused persons have some injuries on their body. On being asked, the accused persons have also submitted that they have injuries on their bodies. Moreover, the following injuries are seen on the body of the accused persons. Please skip over to the next page, my lords. First subpara. On being asked, accused persons stated that they have been arrested on mere suspicion and they have been severely beaten up by wooden sticks by the police personnel at Azara PS. They have also been made to lie on the ground, facing their chest in the floor, and police personnel wearing leather boots stepped on their back to torture them. Further, the police personnel of Azara PS has slapped punch on their face and head mercilessly, due to which they have received serious injuries. Now, IO is absent today before the court. Accordingly, this court deems it fit to direct IO and OC of Azara PS to be personally present before this court and to show cause as to why such injuries have been inflicted upon the accused person and why appropriate action shall not be initiated against them. Inform OC, IO, send a copy of this order to the commissioner. Well, this is the reason I suspect, my lord, the IO has given an adverse report. They have no business to all these things, my lord. My humble submission is.
So what provision is this permission required? This is for what? Law and order.
My lord, page 18 is the order, my lord.
পারমিশন বললে কি পারমিশন বললে পুলিশ একটা কি আছে নাকি?
Now, this is the order which was given on an earlier occasion. It is for general. It is for general information. The District Deputy Commissioner of Police are hereby allowed to accord permission to the Bihu committees during festive season of Rongali Bihu, keeping in view the administrative convenience and fast tracking the process. So, my lord, the Commissioner of Police delegated the power to the jurisdictional Deputy Police Commissioner. Well, that's a very important query, my lord. Normally, my lord, a permission from district administration is required for any event, my lord, because there is a question of maintenance of law and order and all, so that everything is under control, so they can have an eye on what is going on.
Now, we'll have to ask them to give the reasons why, what is the report?
No, my lord, apparently there is no reason in the impugn order. So, my lord, having regard to the fact that it's a Bihu is an event, my lord, which is associated with the cultural life of the people of the state, and therefore they should consider it. Tomorrow is the function, my lord. And page 18, my lord, if your lordship will kindly come to the first subpara, they will consider the law and order scenario, security concern, and traffic congestion at the time of according permission, and ask for mandatory security requirement to give like adequate lighting, barricade, CC camera, volunteer, water tower, etc. So, my lord, these are the basically the provisions which are to be provided by the organizer. Basic idea is to maintain law and order.
Yes.
So on the basis of the report from the officer in charge, Azara police station officer,
What does it say?
Report to follow.
next page, Lord. Not clear, sorry, Lord.
Same thing. The report has been reflected in this order. Do you maintain the proper law and order?
Exactly.
Bandobast is required, you maintain it.
They will also have sufficient volunteers, Lord.
Yes, definitely will do.
If you want volunteers to maintain law and order, may not be a proper idea.
The cooperation from the both sides is
Yes.
Third, come. The grievance of the petitioner is the rejection of the petition. The cultural Rapur, Alibi, on Pilon. The petitioner is the petitioners 1 and 2 are their what secretary.
My lord.
Petitioners 1 and 2,
Yes.
their secretary and what?
Secretary and joint secretary. my lord.
Secretary and joint secretary. Submitted that program was originally scheduled on 26 and 27th of April 2020 in the Harapur
General secretary.
playground. spot.
Krishna Kanto to secretary.
On 27th, when the cultural evening was being continued because of cloudy weather, there was the panel of the program also collapsed and further led to some law and order situation because of which certain persons were taken into custody and the concerned authorities have also lodged an FIR registered as a Tara case number 95. The program was deferred and the same has been fixed on 25th of May on the receipt of confirmation from the concerned artists, and consequently the petitioner approached the Deputy Commissioner of Police West Bombay District seeking a permission to hold the aforesaid program. By the impugned order dated 2025, but they sought the permission by filing their application on 20/05/2020. He said application came rejected by the impugned order dated 25 court, whereby the permission to hold the cultural program is denied. The reasons as is mentioned in the order are on account of law and order situation caused by certain miscreant who indulged in vandalism, also assaulted the policeman, his personnel on duty, resulting in injury of as many as 11 of his personnel. Learned counsel for the something that the situation on that particular day, which is on 27th of April, was beyond control, human control, as same has been resulted because of stormy weather, and the program had to be postponed, and there was some disappointment among the local people and the fans and the people who had gathered or assembled there to enjoy the and the police personnel had been was duty police personnel who were present immediately brought the situation under control. So it is submitted that this permission has been permission for holding this program are required to be granted in terms of the earlier order dated 2024 by the Office of Commissioner of Police, whereby it's clearly mentioned that the district deputy commissioner of police are to allow the BU committees to accord permission to the BU committee to hold their programs during the festive season of Holi Bihu of 2020. So, insofar as the district commissioner of Police West is concerned, other application, one of those statements mentioned in the same order. Copy of this order is available at page 18. The senior counsel therefore submit that denial of holding the denial of the permission dated so and so by the DCP is contrary to the very order given by the higher police authority, namely the by the order. He submits before the court that proper arrangement has been made by the new committee and sufficient volunteers have also been put in place to ensure that no untoward incident will be caused during the program. So the program is scheduled to be held on 25. Our contra Mr. and Government Advocate on notice has submitted that the rejection is on the basis of the report given by the OC other station. See other station has the report given by the OC other station essentially is also reflected in the order. Upon hearing the counsel to the parties that in the face of the order of the Commissioner of Police dated 18/3/2024, whereby the DCP of the various police districts are permitted to afford permission to the BU committees to hold to function. It will be in keeping in view the interest of the wishes of the people of the community, the culture of the state, that the program organized by the so and so committee but permitted to be held as scheduled. So the law and order situation apprehended by the law and order situation referred by the Eviction order in terms of the earlier date on which program was fixed will be taken due note of, and the police authorities are directed to ensure that no such law and order issue arises tomorrow, and for which necessary police arrangement with sufficient police force be organized to ensure that the program is carried on peacefully without any hindrance. So it is further directed that the writ petitioner will also ensure that sufficient volunteers of their committee members will also cooperate with the law enforcing agency to ensure that no such incident is occurred. So the committee members are at liberty to suggest means and ways to ensure that the program passes off without any hindrance. So, writ petition accordingly stands allowed if your order dated so and so shall not be enforced. Or should we keep it pending?
No, it's not required.
Shall not be enforced. So having ordered as above, the court also grants liberty to the law enforcement agency needless to say that in the event any untoward incident does take place, superior authority, namely the Commissioner of Police, is at liberty to take appropriate action. if the need so arises.
And my learned friend will communicate the order because tomorrow is the function.
Copy of this order be part to the office of the learned government advocate to be communicated to the for onward committee.
Diplomat.
You may also serve a copy.
Will also do.
I thought I pray for an adjournment matter on behalf of Mr. D. Deka, my lord.
The prayer for adjournment is made on behalf of the DDFA. That the matter be taken apart.
There is an interim matter that will be. A coercive action not to be taken, but in regard that notice, my lord, which has been given.
How much time do you require?
My lord,
Why are you seeking an adjournment?
adjournment because my lord, Mr. D, my lord, the council, he is not available today, my lord. There are some difficulties with him.
Then we fix it next week.
Yes, my lord.
Matter be listed on 29th of May.
Yes.
Interim order for 30 will continue till the next date.
Obliged. Date visit.
Similar cases are pending, a series of cases have been tagged together, madam. Like these two cases tagged together, madam. We are challenging that 2% royalty by the forest royalty demanded by the Mines and Lands Department.
Take together with,
Application number 2040-2023.
it is submitted that similar petition is pending before this court. And the this petition be placed before be tagged along with
WPC 2040
WPC 2040
2023.
of 2023.
2023.
More than 40 cases are there, money already been tagged, madam.
And how many cases are there?
Till now, I think more than 20 cases have already been tagged.
Along with the other cases. Please take over.
Please, your lordship. My senior is on legs in other court.
My lordship, kindly peruse the last order, my lord. Already, they have not filed their instruction, they have not produced before this. And my lord, the issue is very simple matter. Already lordship has decided this amnesty before this.
Well, if he's available, call him.
Man.
Call your senior if he's available.
Yes,
Take it
sir.
up after some time.
Yeah, please, your lordship. The petition for possessing a ceiling surplus 10 lordship. During 2 parts, 10 less lordship. 2 parts 10 less lordship, ceiling surplus and possessing lordship. Since 1993 lordship. Without any proper demarcation and without pay proper compensation, they have evicted the petitioner. Partly they demolished the house of the petitioner lordship.
Right. In this case, instructions are awaited, Lord.
Sorry?
Instruction is not received, Lord.
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 Do it under 2 weeks.
Lord.
Your Mr.
G.G. Gomez.
It is a lot. My lord, the issue in this case, my lord, regarding nominee. My lord, two people, my lord, the one, Mr. Nalini Kumar Chaudhary and Mrs. Julie Chaudhary, during their lifetime, my lord, they my lord, appointed nominee to the petitioner, my lord, and after that, my lord, he applied for, my lord, for deposit, to transfer the deposit to him, my lord. But, my lord, they are denying, my lord, and they are making disputed. Because, my lord, as per law, my lord, section, my lord, 45 grade A, my lord, it is clear that, my lord, once nominee is there, my lord, the bank authority, my lord, has to be, they are insisting, my lord, on succession and other, my lord. This is not concerned for the bank, my lord. And, my lord, Lordship may kindly see one form, my lord, which was on in record, my lord, and the original also with me, my lord. This shows that, my lord, they already appointed nominee, my lord, page 16. Annex 3, my lord. My learned friend file affidavit, I also I reply this, my lord. This is the petitioner, my lord, left side, Dibbajati Dekha. My lord, the relation is shown as family member. And account number is also there, top, my lord, left side. My lord, as per my lord, section 45 JDA 1 and 2, Lordship may kindly bear, my lord. Law is very clear, my lord, in this.
Yes, what do you say?
Yes, your lordship. Your lordship, page number 34 of my affidavit in opposition. Your lordship, here is the projection is that he is the son of the deceased. And the petitioner has mentioned his father name in the writ petition as Hemchandra Dekha at page number 2 of the writ petition. And in the page number 34 of my affidavit in opposition, that there was a declaration that Divyajyoti Dekha, the relationship is son. Point number 14, point number 15, and point number 16. But the person who is applied before us is not the son of the said deceased. Whatever be the KYC that has been produced before us is not matched with the nomination report before us.
Yeah.
That is why we suggested him to take out the succession certificate from the civil court so that we will settle all the issues.
My lord,
There is nothing.
in this regard, my lord, I'd like to one judgment, it's not judgment of the Honorable Supreme Court.
What judgment you'll give, clear the fact first.
My lord, Lordship may kindly see my
KYC
petition.
says he was the son.
No, my lord, they had treated as a son.
Huh?
My lord, the couple treated him as a son, my lord, and Lordship may kindly see the document which I produced in my writ petition, my lord. Lordship may kindly please page 17, my lord.
Yes.
Is the medical certificate, my lord. And the guardian's name written as a Dibbajati Dekha, my lord.
Guardian, not son.
No, sir.
Eh? The KYC is meant to identify the customer.
Lordship.
The customer says you are the son. So you are not the son.
No, I am not the son, my lord.
So you get
He
the
is-
order of the court. Get the
But my lord, law is that once a nominee entered in the record, my lord, Lordship, I have shown Lordship the page number, my lord, that is 16, my lord. And that is during their lifetime, they have, my lord, made him the nominee, my lord. Once he is nominee, my lord, my lord, any person, my lord.
Here also he is mentioned as family member. He is
Yes,
not
my
a
lord.
family member.
You are not a family member.
No, my lord, he is, my lord, when they are in, my lord, they have no son and daughter, my lord. That's
Still you argue like a lawyer.
Lordship.
If for a family member, there must be a relationship or there must be a document of adoption.
My lord, they have treated
Like
as
a son, like a family member, it does not in legal parlance make you a family.
my lord, they, all those documents, my lord, I have shown in the writ petition, my lord. they have treated as a my lord, their son, my lord, during their lifetime. So they have no son and daughter.
Will we dismiss it or you'll withdraw it? Or you
Well-
want a dismissal on some other day?
Well, some other day.
You want to argue the matter, argue it properly.
Right.
Matter be listed after next week.
Thank you.
Special Learner Council. Mr. M. Sharma, I will be responsible. Thank you.
Right.
Lordship, can you pass about a metabolic time D news on let's go.
It will come next week. Matter be listed next week at the request of Learner Council.
46 also.
Okay. Next week,
46 also.
46. Okay. Right. 45, 40. Right.
May I please, your lordship, kindly matter be passed over for the time being.
Council, prayer is made on behalf of the council for the petition. Seeking accommodation for the day, the passport for the next the Hazari.
Correct.
Beach of beach of Robert. Yes.
I find my affidavit one. And he has got a full respondent. Reply has come.
Hmm?
Find the reply. Yes, they find the reply. Basically, this find the order in page number 15 onwards. Personal part is at page number 28 onwards. Last two lines.
Page number?
Page number 29, last two lines, from the, however, the associate position is Mr. Bora, the learned counsel, however, submit that a bill can be cleared only after verification measurement of the work done for the period of the order. In view of the above, the circumstances, both the parties are.
I'm unable to find the play.
Lordship, page number 29.
29.
29. In view of the process, facts and circumstances of both the sides, both the written are disposed of with the direction the GMC GDP to undertake a verification exercise, which would include measurement of the work done. It is needless to mention that first half measure have to be done in presence of the representatives of the petitioner, so that no duty is caused to the header of the party. It is clarified that the measurement had to be done independently for the individual work. This order was passed on 2012-2023. And this all utilization exercise was done in 2021. In the meantime, I have filed my affidavit. The exercise has to be done once again in the presence of the petition done. Exercise has to be done once again in the presence of the petition. That exercise cannot be done, my lord, because already in 2021 that exercise has been done, and the monsoon, 3-4 monsoon has come in between. That can be cannot be redone. In fact, my lord, if lordship takes out my affidavit, my lord, we tried to do it again, my lord, as per direction of the court, my lord. All the divisional chief, division engineers and all has given the report to the commissioner that the report starts from page number 37 onwards, my lord, starting page number 37 onwards, that the exercise which has been done, already done in the 22, cannot be done again, my lord. Because this is regarding deceleration of the train, my lord, that deceleration is done, it is near the roadside, and that exercise has already been completed. It cannot be remeasured once again. basic thing is that they want the amount which has already been, they have undertaken the work, the amount they want to be with it released.
Yes, what do you think?
My lord, this matter may be addressed by Mr. S. Botagon. He's on his way, my
Have it next week.
Lord.
Again on it's next week.
Well,
It is submitted with the council. The rest for it is for the TMC. TMC.
No, this is the content of the pattern.
Sorry. Yes.
my lord, a date may be fixed.
He'll come next week.
Deep development.
The order has been complied with.
The matter may can be
Submitted by the council. The order is right with. Prayer, same statement not disputed by council. Respondent taking into account statement submitted made by the council. The contempt statute. This is the issue.
Public.
Your Honor, the orders have been complied with, Your Honor.
Who's for the petitioner? It's submitted by
Responding one.
council appearing to the respondent. That the directions contained in the order dated to pass the WPC square to then it's complied. Accordingly, the contempt petition to
May I please, Your Lordship? Lordship, this is on contempt petition. Here, Lordship, we have filed this contempt petition due to non-compliant of order dated 28/07/2023, passing WPC number 2239 of 2023. If your Lordship will find operative part of this order at page 10, Your Lordship.
Where is the order?
Operative part at page 10, Your Lordship.
10.
10, paragraph number 5, Your Lordship. In this order, Lordship, our case was considered with the direction to the respondent contender. The petitioner case may be considered within a period of 2 months. Paragraph number 6, after being received the certified copy of this order. But yet it has not been considered by the contender.
Anyone for the respondent? Yes.
Other food, my lord. So, 2 weeks time. Maybe
Next week. All right, we'll give you 1 week.
My lord.
Submitted that council appearing for the
we already compliant.
respondent is not available for the proxy council or accommodation for review. Mr. Akan.
Yes.
Appears for the. Yes.
Sorry, Your Lordship.
Order complied?
Lordship, this has come for the first time after the issuance of the notice of the, let's take some time.
Then I council for the response. Review. Yes, have you filed your affidavit?
No, I just filed my wakalat nama. 6 sometimes will take instruction.
3 weeks time. Then start. No? Yes, sir.
Deeply obliged. Sure.
Step
Dr. Kindly peruse the order with 12,364. I have
12.3.
not both orders, but I have submitted.
What was the direction here?
Page 15, my lord. There are 6, 7, and 8.
Then they could.
Compensation.
You are filing contempt for non-compliance of what? Which order?
My lord, order that, my lord, 8/2/2023, my lord.
8.
Yes. WBC number 6279 and 6281.
Page number, please.
Page number 10, my lord.
10.
Yes, sir. 11%, page number 15. Paragraph number 6, 7, and 8.
Where is the order dated 8/2/2023?
My lord, page number page number 13, my lord.
Okay.
Now, what is the purport of this order?
After this order, my lord, 8/2/23, a verification process has been initiated by the department, my lord, on the claim of the petitioner, my lord. On verification, the deputy secretary, it has been found that the relevant compensation cases as claimed by the petitioners of the above cases are not registered, my lord, in the office of the deputy commissioner, my lord. All the compensation cases mentioned in the petitions are not found in the official records. Considering the facts and circumstances, the petitioner also were heard by the deputy secretary in presence of the ADC, Karimganj, to give reasonable opportunity to the petitioners to produce any official documents on their hand to support their claim, my lord. As per report, the petitioner Monunath and Rajannath have stated that they are unaware about the area of the land acquired and compensation to be paid for acquisition under the Assam State Eviction and Dominion Act 1951, and also not received any notice from the then compensation officer against the compensation cases claimed in the writ petition. The petitioners were also not able to produce any valid official records in support of their claim, my lord. The petitioner have stated that one Iqbal Bahar Chaudhary has
Bring it on record.
my lord.
Bring it by way of an affidavit.
My lord. One of the content is already closed, my lord.
On this basis,
In this basis of this,
have you received a copy of it?
yes, then they are aware, my lord.
One case is closed.
So the order is complied with.
On
Yes.
8/5/24,
This
my
is,
lord. Honorable Mr.
I haven't challenged it.
Hold on.
Huh?
I haven't challenged it. The one case is
Heard
already
the
closed.
counsel to the parties in terms of the order dated 8/2/2023 passed in the number
6 to 7 now.
679 read with order dated 2004/2023 in IA Civil 474 of 2023. The court directed the claim of the petitioners for the compensation to be entitled to be released after proper verification exercise was carried out. Verification exercise was directed to be completed within a period of 45 days from the date of receipt of a certificate order. Pursuant to this order by the court, by order dated 12/3/2024, the Department of Revenue and Disaster Management carried on the necessary verification and passed this order rejecting claim of the writ petitioner. Now that compensation cases claimed by the petitioners WPC 6271 of 21 and 6281 of WPC 6281 is of
For Rajannath.
which year?
21, my lord.
21.
Both are
21. Have not been registered in the office of the deputy commissioner and therefore not processed. No case records are available or found to have been forwarded. to the government. So that view the prayer for compensation. So, having heard the account of the contempt petition is closed and the direction contained in the order dated 2025 WPC number 679 of 2024, placed to the court by the counsel for the respondent, is kept in the case.
My lord.
Innocent Goldberg for respondent one. MS RM Purva appears for respondent number two. I'm a peer model.
Please, Your Lordship. My lord, hearing has been taken, hearing of the petitioners. Only order is awaited, my lord. Deputy Commissioner is to pass a speaking order.
All right. Matter be listed after 2 weeks, by which time the respondents will complete their instructions and apply the court whether the order dated
Order dated 11/8/2023,
2023 passed in WPC number
4557.
4557 of 2023. It is submitted by the counsel to the petitioner that the hearing has been conducted by the Deputy Commissioner
District Commissioner
of
Dhubri
Dhubri
on 16th of March.
on 16th of March. No order is passed. According to this, the matter after.
Published.
In this case, Your Lordship, service is complete. Your Lordship, may kindly see the order of the lodgement. So far as respondent number 4, Your Lordship.
Do you want to take dusty?
Service complete, Your Lordship.
Complete.
In fact, Your Lordship, our basic grievance is against state, Your Lordship, is against the freezing of a bank account, Your Lordship. They are formal parties since the account is in their bank, Your Lordship.
As per Lozima order dated 25/2024. Service is deemed to be complete. Service is held to be complete in respect of respondent 4 as per the consignment note, consignment report. The notices have been confirmed to have been delivered in the address of the court. The rain goes from here for
120, and we final. If they have filed their affidavit, Your Lordship, may I pray for taking up this matter on court, Your Lordship.
Court.
For freezing of a bank.
The respondents have also, respondent 1, 2, 3.
Lordship.
Have also filed their affidavit. Counsel for the petitioner submits that the matter be taken up on court. It's not court.
Deeply obliged.
Yes, yeah.
Okay, in this case, I was supposed to obtain written instruction. Oral instruction I have received. The matter is Lordship, there the registration was cancelled on non-filing of return. What happened thereafter they preferred appeal. Appeal was dismissed on the ground of delay. And the authority has no power to condone that delay. And there is a Supreme Court judgment to that effect also. Now, I have obtained instruction, they can apply for new registration that can be given by the authority. The court said that you have obtained written instruction. But my officer was out of on leave on Tuesday.
My lord, my lord, my lord, if you lordship permit, my lord. Already the two judgment which has been appellate authority has been relied, my lord. That they have stated that the appellate authority cannot condone the delay beyond the statutory period, that is the 90 days. First of all.
Secondly, my lord, there is a judgment of this law of his lordship in lordship kindly see that is the 2017-11 SCC 730, my lord, in paragraph number 9, my lord. The my lord, the quasi judicial authority or the appellate authority of the particular department cannot condone, but the writ court can condone the delay under Article 226 of the Constitution of India, my lord. When the matter relates to fund enforcement, my lord. Yes, my lord. My lord, there's a part hard. Yes, my lord. Otherwise, matter will be.
Mr. NHIDCL,
Yes, sir, ma'am.
It's up to